for keeping your dials here on 99.5. Here in Accra, 98.5 in Kumasi, 100.3 in Cape Coast, and 99.7 in Tamale. My name is Baffour-Awuah. Let me sincerely welcome you to today's edition of The Forum. The Forum is your weekend political and current affairs show where we put the spotlight on major issues making the political rounds in our country. We bring multiple ideas to bear on these issues and anticipate that we leave you more informed than you probably were when this program started. Today, I have a dream team that is joining me, some via video link, some via telephone, and some in person here in the studio. And we are going to be discussing two major issues. The issues to do with our Chief Justice, the Chief Justice of the Republic as by law established, Justice Gertrude Araba Isaba Sakitokonu, and then issues of the Ghanaian city will also come to bear in today's edition. But before I start the conversation, introduce my guest and what have you, let's take a quick look at some three newspapers I've picked from the newsstands this morning. The first is The Mirror. The Mirror is Ghana's most popular weekend paper, established since 1953, and has a series of stories here. Accra vendors reject 20 Peswa coin, and it appears that they were first rejecting the brown one. I've forgotten the denomination, and then the 10 Peswa was rejected. Now it's moved to the 20 Peswa coin. So yes, that's what the story here and The Mirror is talking about. Is on page 3 of The Mirror. If you get a copy, you can get the details of the story there. There is a rather disturbing, sad, but well, you can say that healing story, and it's about a lady by name Sarah Ibrahim, and the story says that I screamed but no one heard me. Sarah Ibrahim's story of defilement, loss, and healing. And so this story comes with a picture of the beautiful Sarah Ibrahim talking about how that she used to help her mother to sell somewhere around Awoshi, a man who indicated that she was owing Sarah's mom, and so Sarah should come to his home to collect the money. Sarah ignorantly went into this man's house, and the end of the story was that this man, I don't know whether I should call him a man or I should call him something else, but this man ended up defiling Sarah Ibrahim. But she's gone through the process. She screamed, nobody heard her, but she's been able to go through a process of healing, and she's telling her story on the front page of The Mirror. I started reading the story. I couldn't finish it before coming on air. It's on page 10. I find it quite an intriguing story, and so grab a copy of The Mirror. You can hear Sarah's story, and you probably know somebody else who went through such a problem, and you can advise the person through the story of Sarah. Quickly, that is The Mirror for you. So The Spectator is the next paper, and The Spectator says that invest in museums to fulfill Nkrumah's vision, government urged. And so stories on page 3, the government is being urged to invest more in museums in the country because it was Kwame Nkrumah's dream. Okay, so Dr. Ifa honored at 2025 Millennium Excellence Award. Stories on page 12 of The Spectator. And perhaps the biggest story on the front page of The Spectator this morning, fashion at TGMA 2025 falls short of expectations. And this is according to a fashion PR. The fashion PR is Fitsenam Oklu. Fitsenam Oklu is the one making that assertion. Says that TGMA may have gone well, but in terms of fashion, the fashion industry was disappointed. All right, so go to Fitsenam Oklu. Maybe she has better fashion suggestions for those of you who went to the TGMA 2025. Last paper, Daily Graphic, Weekend Edition, Truth and Accuracy Every Day. And this is number 22,767. The stories here. Murder of Sogakope Assembly member. Mason gets life to receive 47 years each. Stories on page 13 of the Daily Graphic. And it's a story talking about how that a Mason, together with two others, murdered the Sogakope Assembly member. May his soul rest in perfect peace, and may those sentenced to prison also enjoy their stay in prison. All right. Preach against drug abuse in churches and mosque. Interior Minister urges religious leaders. And this story is by Muhammad Fugu from Tamale. And the story says that the Minister for the Interior, Muhammad Mutaka Mubarak, has made a passionate appeal to religious leaders to use their platforms to preach against the growing phenomenon of drug abuse. He was addressing a section of religious leaders as part of his 3-day working visit to the northern region last Thursday. I think it's a very good call. I don't know whether we can get all the drug users and co in the church or in the mosque, but maybe when the message is preached, it will go out there, it will be broadcast all over, and we'll be able to help the brothers and sisters who are into drugs. All right, so that is the 3 newspapers I have picked from the newsstands this month, and we've just gone through them. Now let's settle down and look at what we are discussing this morning. Now on the show this morning, we are looking at the Chief Justice's request for her own ongoing secret trial to be made public. It is a request from the Chief Justice herself to the Supreme Court. And we are going to be discussing that and all the matters arising from the committee hearings and what have you. And then we make time, we will talk about the CD appreciation and whether or not it is sustainable. If it is sustainable, what is really going to be done to sustain it? If it is unsustainable, what are the measures that need to be put in place to turn the tide, to make sure that it is sustained? And then also, who really takes the credit for this interesting turn of events? The CD a few months ago was about 16 cedis to $1. As we speak today, it is about 11 or perhaps a little lower than 11 cedis to $1. That's an interesting development. And so we get to talk about it today. My guests who are joining me for today's discussion from diverse areas of society, and they are all joining in to make sure that this conversation becomes what it is. And so we will have Nana Eje Baffour-Awuah. He is a member of parliament for Menchia South and a lawyer in private practice. He's going to be joining us on the show via telephone this morning. And then we have George Domfe, who is the development economist and lecturer at the University of Ghana. He will join us specifically for the CD conversation. We have Oxford Osei Bonsu. He's a lawyer in private practice, and he's also going to join us and bring his perspectives to this matter. The 2 regular guests, Nick Pakpo Samoa Ado, is a lawyer. He is a member of the NDC, and he's also going to be joining us this morning in studio. Kwame Jantwa is also a lawyer and a member of the Convention People's Party. He's also going to join us in the studio this morning. And so that's how our show is looking today. And we anticipate that it's going to be an interesting one. Maxwell Apia Dankwa is already engaging on Facebook, and he says that this perverse but not this man. So I believe you are talking about the story on the front page of the Mirror, I believe, on the defilement of Sarah Ibrahim. Well, so Maxwell, thank you for your message, and that is to tell everybody who is joining us on Facebook, share our page, tell somebody to tell another person. The forum is airborne. If you send your messages, direct messages contributing to the discussions on the table, we'll read them, we will share them with the whole world. And if you even send a follow-up, we will add up and read that as well. So thank you very much for choosing Asasi Radio. We will start today's conversation on the issues concerning the Chief Justice. And these are matters. Now, it will interest you to know that there is a ruling that has come out from the Supreme Court with regard to these whole issues concerning the Chief Justice. It is a ruling, it's an 81-page ruling. And it is the case of Vincent Assefuah versus Attorney General. And this was an application for interlocutory injunction. And it was a 3-2 majority decision. And if you take a look at the ruling, as I have seen and trying to read through it overnight, you would see that there is a lead judgment which was, or lead opinion, which was authored by Tanko Amadou. He's JS, he's a justice of the Supreme Court, and he authored the lead judgment. There is a concurring opinion written by Yoni Kolendi. He is also a justice of the Supreme Court. And then there is a dissenting opinion which is authored by Justice Henrietta Mensah Bonsu. She is also a justice of the Supreme Court, and there's no concurring opinion, but Justice Gau agrees with Justice Henrietta Mensah Bonsu. After reading through the ruling, I get the impression that the star in the ruling is probably Justice Henrietta Mensah Bonsu, because she says some very interesting things, page 66 and page 76 of the ruling. Very, very interesting things. We get to talk about it. I'll ask my panel what they make of it and all that. All right, so let me go to the telephone lines, and lawyer Baffour-Awuah is joining us via telephone to share his thoughts with us on this matters arising. A very good morning to you, my dear counsel friend.
Good morning, my brother. How are you doing?
It is well. It is well. And it is good to hear from you this morning.
Good to hear from you too.
Yes, yes. How is the constituency doing, Menchia South?
By the grace of God, we are keeping well.
Okay, all right. So one of these days, we get to come and do the Asase breakfast show from Menchia South. Yes.
It will be a privilege.
Yes. We'll get to come there.
A privilege.
It's been planned, so maybe I have gone ahead of the planners, but that is just to tell them that they should hurry up with the plan.
Sure.
Okay.
Sure.
All right, counsel. So, we have all been dealing with these issues of Chief Justice. We learnt of this before Easter, somewhere on the 22nd or so of March, and then post-Easter, we came to the point where the Chief Justice, I think it is just the day after Easter, 22nd of April, and the Chief Justice gets suspended. Today is the 24th of May. That means that the Chief Justice has been in suspension for a month and 2 days. And matters are still ongoing. Where we are right now has to do with the Chief Justice saying that I don't want this process ongoing to be a secret process. I don't want it to be in camera. I want it on camera, because I think the whole country should be taken along, especially when the whole country has known all these processes from start to end. So the president first announced the process. It was a statement to the press. There's been other releases, even with the committee's work. When they were about to start their work, there was a press release from the presidency.
If you can speak up.
Yes. Okay. So the question I'm asking, I'm just trying to lay a preamble to the question. But really, the question I'm asking is that the Chief Justice is at a point where she's filed an application at the CJ's court, which is the Supreme Court, and saying that I want the ongoing investigations to be made public. What are your thoughts on this request by the CJ, having in mind the constitutional provision that says that this process should be held in camera?
Good morning again. When you look at the position of the Chief Justice being the head of the judiciary, and the judiciary itself is a trustee of the justice system for and on behalf of the people, ordinarily, shouldn't the people know what is going on? Shouldn't the people see what is happening? Especially because she was also approved by Parliament, for which reason you would want to believe that the people were involved in her appointment. In the removal process, Parliament is not involved. The people don't also see what is happening. And so ordinarily, her call should be a legitimate one. That said, Article 16468, right, has made it mandatory that the hearing should be in camera. And so it makes her call a difficult one to accept. But let's look at this. what has been the Supreme Court's own interpretation of Article 1468 should be the question. If you look at the way the Supreme Court has approached Article 1468, it's as though it's an inconsequential provision of the Constitution. Why do I say so? When you look at Erie versus Attorney General, the Supreme Court, even though acknowledged that it was mandatory for the proceedings of a removal of a justice of the Superior Court to be held in camera, right? It also went ahead to say that a breach of it was unconstitutional. It nevertheless stated that the breach of Article 1468 will not invalidate the Article 146 removal proceedings. Okay. Mm-hmm. And so if a breach of Article 1468 of the Constitution will not invalidate the removal proceedings, the impeachment proceedings, then it's an inconsequential proceedings, inconsequential provision. So, to the extent that when it is breached, it will have no consequence on the provisions, right? Mm-hmm. And so when you look at it from that perspective, an untrained eye very respectfully may say, okay, if you have come to the conclusion that a breach of Article 1468, right, should not have a consequence on the impeachment proceedings itself, then why don't you allow the Chief Justice's request, taking into consideration the circumstances that we find the whole thing in? Why don't we allow her? That's where the difficulty is. The difficulty is that, notwithstanding the Supreme Court's own approach to Article 1468 of the Constitution, notwithstanding the Supreme Court's own approach to a breach of Article 1468 of the Constitution, the court or the lawmaker, the executive, the legislature, and the judiciary cannot be seen to be breaching the Constitution. And so, in order not to be prejudicial, we need to ask ourselves the question, right, that given the position of the Supreme Court, in the case of Derry versus Attorney General, as far as the breach of Article 1468 is concerned, is the request of the Chief Justice permissible? That is the question. Is it permissible? My simple response would be, and I would want to couch that in the form of a question by saying, will the court want to be seen to be involved in a breach of a constitutional provision? Well, the doctrine is one of the situations where the doctrine of necessity may be applicable. I'll leave that to the court.
Okay, so I'm reading so interesting preliminary thoughts that you have shared there, and my take from what you are saying is that in a previously decided case by the same Supreme Court, they said that indeed when Arabia Anas aired his findings at the I think the International
Conference Center,
Accra International Conference Center, for the whole world to come and see what he's alleging against judges, he breached the provision about in-camera hearings or the in-camera process in the removal of justice. But the court said that nevertheless, irrespective of the breach does not necessarily take away the substance of the matters that was before the court.
They effectively said that the breach didn't render the proceedings invalid because there are two stages that are likely to truncate the processes, and none of that has happened. The two stages being the determination of prima facie or otherwise or the post prima facie proceedings. That is what the court said. And so, to the extent that the airing of the petition, right, did not affect any of these stages, right, it should not invalidate the processes, the proceedings. The proceedings should go ahead. You understand?
Okay.
Now, what that means is that there is an admission that Article 1468 was breached by the airing of the petition by Anas. The Supreme Court acknowledged. Okay, except to say that the consequence of that breach, the effect of that breach, right, will not impact on the proceedings to the extent that it will render that whole proceedings invalid. Okay, if that is the case, then the airing, which is the publicity of the proceedings, right, should that be a problem? Should that be a problem? That is the question that needs to agitate our minds. Okay, if it will not be a problem, the question that will follow is that, to the extent that even though the airing of it will not be a problem, but nevertheless reaches Article 1468 of the Constitution, into bracket, which mandates an in-camera hearing, will the Supreme Court or officialdom be ready to breach a constitutional provision? Because in the case of Anas, it was a private citizen that breached it, and they could go away with it. Well, public officials be ready to breach a provision of the Constitution. My brother, I've said it elsewhere, and I'll repeat on the show. To a large extent, inconsistencies in judicial decisions is what is giving us problems now. It's inconsistencies. You know, very respectful. When you look at, there's a decision involving Huawei, a case involving Huawei. Justice Clement said something that has been weighing on my mind for some time now. He said that Powers is one of judicial precedents. For us, our law, judicial precedent is key. That is what guides us. That is what informs us. That is what makes our laws predictable. And so you cannot have a court that say something today and say another thing tomorrow. That is the situation we have found ourselves in for some time now. Sometimes the reasoning given, and so you realize that subsequently the court will be running away from its own decisions. You understand?
Yes.
That is the problem now. And that is why I took you to the Anas matter. Anas had gone to show the video at the International Conference Center involving the judges' bribery scandal. And my good friend, Papu Samoa, who will be on your show this morning, will remind all of you that he took issues with the showing of the scandal, and then went to the Supreme Court and said that when you look at Article 146 of the Constitution, that is the entirety of the impeachment proceedings of our Superior Court judges and the Chief Justice, the petition itself forms part of the impeachment proceedings, which is supposed to be heard in camera. That is in secret. And so by going to show it at the conference center, Article 1468 of the Constitution, which mandated an in-camera proceedings, had been breached. And so the whole proceedings should be declared null and void. I appreciate the difficulty of the Supreme Court at the time, that given the enormity of the scandal, the fact that it had attracted international attention, taking a position that the mere airing of the petition would render the proceedings null and void to the extent that these judges could go back unpunished and could resume their positions was going to be equally scandalous and affect the integrity of our judiciary and indeed our judicial system. And so they needed to do something. But in my humble view, the reason given, right, for coming to the conclusion that the airing of the petition at the nationality, at the conference center, right, and for that matter, reaching Article 1468 of the Constitution, in my humble view, right, they could have done better. If you had approached it from the perspective of the doctrine of necessity, then people would have appreciated it. Okay? Because you didn't do that. Today, because the reason was very respectfully not weighty enough. Today, somebody is telling you that she wants to waive her right to in-camera hearing because you did not even delve into the principle of in-camera hearing well, to the extent that it is not a right that belongs to a judge. It is a corporate or an institutional right. And so you enjoy it as a judge or a chief justice, right, by virtue of you being a member of the judiciary, right? And for that reason, even if you alone are given a right, you are going to affect the entirety of the judiciary by reason of your enjoyment of it. Okay? And so it's more or less like a collateral benefit to you, not a substantive right.
Okay. So, Counsel, yes. I'm going to ask you about some two reliefs that the Chief Justice is seeking. But how do you reconcile the argument you are making right now with the provision in the 1992 Constitution, which says that, I think it's Article 129 of the 1992 Constitution, says the Supreme Court shall be the final court of appeal and shall have such appellate and other jurisdictions as may be conferred on it by the Constitution or by any other law. Clause 2 of that article says that the Supreme Court shall not be bound to follow the decisions of any other court. And Clause 3 says that the Supreme Court may, while treating its own previous decisions as normally binding, depart from a previous decision when it appears to it right to do so, and all other courts shall be bound to follow the decision of the Supreme Court on questions of law. I want you to marry the argument you are making with this provision in the 1992 Constitution, Article 129, particularly Clause 3.
You see, the Supreme Court is free to depart from its own previous decision. The essence of the work of the Supreme Court is to do justice. And justice, inherent in justice delivery, is consistency. Because, my brother, I should know the law before I breach it. I should know the law before I breach it. Without knowledge, even though they say ignorance of the law is no excuse, right? The law must be in existence before there is a breach. True or false?
Well, yes.
Can you breach a law which is not in existence?
No.
Good. You cannot breach a law which is not in existence. And so, what is the law today is what we are supposed to follow, and not the departure tomorrow. Do you understand?
Yes.
Now,
yes.
For all of us, there is the consistency in interpretation helps in planning our day-to-day lives, in helping us give legal advice that is sound and comply with due process of law for people to also follow. The fact that you have the power to depart from your previous decision doesn't mean that you can always, give different decisions to similar set of facts or same set of facts. Why am I saying so? A departure, when you are departing, you must take categorically clearly that this is our previous decision. We are departing from it, and you give reasons why you are departing. But when you look at the decisions we have, mostly they are not departures. Do you understand? It is you knowing a set of legal principles and litigating based on it, or having advice based on it, and issues have arisen and there's litigation. Then you go to court and you find that the same set of facts, and the court is giving it a different approach. And so, in taking account the CJ's matter, the Supreme Court may be free to depart from it. However, it is going to be a very let me not go there. If I go there, I'll be prejudicial. Please, there's a risk. There's a thin line.
I understand.
But let me raise the question. The question is that there is Article 1468 of the Constitution that mandates an in-camera hearing. Is Article 1468 a personal right to judges, or a corporate or institutional right to the institution, to the judicial institution of the judiciary? The reason is that is 1468 supposed to protect the persons or a person occupying an office as a judge, or the institution of judges. That is the judicial arm of government. That is how I think we need to look at it.
Okay, so let's take a look at the reliefs that the Chief Justice is seeking with regards to this, and pick your thoughts on it. So if you look at the phase of her writ as has been filed, she says that she wants a declaration that upon a true and proper interpretation of Article 17(1) and 2, Article 19(13), Article 14, Article 23, Article 146, 7 and 8, 281 clause 1, 295 clause 1 of the Constitution, the right of a Chief Justice to a public hearing and all the incidents of a fair hearing may only be excluded in the interest of public morality, public safety, or public order. What are your thoughts you have to share on this declaration that CJ is seeking?
Article 1468 of the Constitution inconsistent with these provisions of the Constitution. Is that what you are saying? That is one of the things the court will be looking at. Let me not be prejudicial. Because 1468 of the Constitution mandates an in-camera hearing. Now, the Chief Justice is saying that on the strength of all these authorities, all these provisions of the Constitution, she's entitled to a public hearing. 1468 is specific, is specially made, right, for proceedings in Article 146 of the Constitution. And so if you are raising all these other provisions and standing on them to say that you're entitled to a public hearing, effectively, you are saying that 1468 of the Constitution is inconsistent with all these other provisions of the Constitution.
Okay.
If that is the case, that is the Supreme Court to look at it. Because you see, when you look at Article 1, Clause 2 of the Constitution, right, it doesn't say that, it doesn't speak to inconsistencies among the provisions of the Constitution. Rather speaks to inconsistency of acts of persons or laws that are rather inconsistent to the Constitution. And so, are we looking at a situation where a provision of the Constitution can also be said to be inconsistent with another provision? Please let me not go there. I beg you.
Okay, so
let me avoid this thing.
I understand, but your friend Dikpaku has joined us, and so I want you to stay on the line. I want to pick his thoughts, especially on the argument you made about the case that he fought very hard for in the courts himself, and then I will come back to you. So yes, please say it again.
Charlie, I'm so impressed with your work in Parliament. You and John Darko are doing us proud as young practitioners who are.
Thank you, my brother. Thank you, my brother. We couldn't have done otherwise.
I'm very happy about how you have, even in your very first
we couldn't have done otherwise, my brother.
Establishing your legal prowess in Parliament. I wish you the very best.
Thank you, my brother.
He's one lawyer that will not engage in personal insults, but will always, put the law.
Talk the law.
Exactly.
Yes.
And I enjoy debating with him every time.
Thank you, my brother.
Well,
thank you, my brother. My brother, you know that we are very faithful to the law. We love the law. We want it to grow. We want the judiciary to do the right thing, because not only because that's where we ply our trade, but also to grow the economy of this country. I'm telling you that unless the judiciary gets it right, or let me put it this way, the judiciary getting it right is so key to unlocking our economic fortunes as a country.
Yeah,
you and I know.
Yeah, Nana, not to cut you, but you see, back in 2016, when Baffour was then a reporter at the court, so he knows that's actually where we forged our friendship from.
Yes.
In 2016, when I took up this case, it was a very unpopular endeavor. Back then in 2016, everybody, coincidentally.
Is it 2015, 2016?
2016.
Okay.
Coincidentally, at the time the story broke, the bar conference was ongoing. So I didn't go for the bar conference that year. In fact, I've never really done the bar conference in person. But in that year, everybody was in, I don't know the city. I think it was Sunyani or 2016, I don't know. But everybody was there, and the tension was high. Because that was the week before was when the story broke. And here was I, a very young practitioner then. And I'll tell a story that I haven't told anywhere. The judges who were concerned, the 10, the very first thing they tried to do was to try and negotiate and I said I'll write a book on this experience. They tried to resign en masse, and it was not accepted. And here was a very young practitioner. They went to some senior lawyers. The senior lawyers said they couldn't take the case. So I was there when they came to me, and said that would I want
did a very good job.
Would I want to take? Yes, I'm telling a story I haven't said anywhere, shared anywhere before.
It was a very unpopular.
Very unpopular. Would I take up this particular case? So I called my partners. My wife, and Stephen Opoku at the time, and I said, "Look, guys, this is the situation. The entire law fraternity is at a bar conference. These judges, some of the, when these things happen, some judges were almost committing suicide. I haven't said a lot of these things in the public before. It is a lot of psychological pressure. At the time, the entire country was against them. They couldn't go out. Their names were out there.
Their pictures
were out there. Faces were out there. And everybody was baying for blood because the story was juicy. Yes, we've always said there was corruption in the judiciary. You see, there's evidence. So at that time, when I decided to take up the case, I remember the first time I spoke on air was on Newsfile, just to give a hint that the judges were going to go to court. And you remember, the bar conference, even the then leadership said there will be justice. Every judge would be held accountable. There was a lot of tension. And I felt that at the time, the two things that I felt very, very strongly about was, number one, procedural fairness. You see, when you read Article 146, it says that there cannot be a removal, or the process of removal cannot happen outside the confines of 146. And so I even argued that the person against whom the petition is against, that's the judge, has a duty to ensure that his removal is in accordance with 146. That was one of the arguments I made in court. And at the time, when I was preparing my arguments, at a point, and in fact, I worked from Friday night till Monday morning. Another time, my wife was pregnant. She was in the court, in the office with me. We worked from Friday night to Monday morning to be able to file the process. And whilst doing the arguments, one of the things that I came to mind was, Even the names that of the judges, when we wanted to define in camera, could not be mentioned outside. That was our argument.
Mm-hmm.
Yes.
So we felt that the Chief Justice's instruction to the Judicial Secretary to even put out the names of the judges was unconstitutional. And the court agreed with us that even the names of the judges could not be put out when they have not gone through the process. So you see, nobody should fault any Superior Court judge who is in the midst of a petition hearing, who is fighting for both procedural and substantive fairness. It is something I stood for in 2016, and it is something I stand for.
Yes, let him come in. Yes.
Let me say something to you. You see, what is happening to Justice Tokoni is the reason why every judge should begin to do things right. Because you don't know when they will be with you to be your case tomorrow.
Exactly.
I remember getting involved in a case where a client of mine, a gold dealer, was accused of having knocked down a police officer, who died, unfortunately. I went to the police station, and there was a crack team of police officers from the headquarters to interrogate him. And I asked that they allow me to have conference with him, and they were resistant. Eventually, I said something that triggered them. I said, look, it can happen to you tomorrow. You see what? That was when the DSP or ASP Tawuda matter was all over. I said, you see what is happening to your colleague Tawuda? It can happen to you tomorrow. So they all got triggered. And one of them, don't compare me to Tawuda. Don't compare me to Tawuda. They always get it wrong. You see, it's not about the person being right or wrong.
Yeah.
But there can even be false accusation or false allegation. And it is only compliance with due process of law that can give you the opportunity, right, for you to vindicate yourself. In the absence of it, people will butcher you in secret and nobody will know.
Mob justice is
you
dangerous.
Understand?
Mob justice is dangerous. So you see, I want to say that the process must be allowed to roll out.
Yes.
Every single legal challenge that the Chief Justice wants to put up, or anybody who is aggrieved by the process wants to put up, must be allowed. I went all the way to the ECOWAS court.
Yes.
I fought this case all the way to the ECOWAS court. Got injunctions that prevented my clients would have been sacked from day one. We had to wait, and I must congratulate. At the time, the then Attorney General was Madame Gloria Kufu.
No. This is 2016. 2016 was under the NDC administration.
Madame Marietta
Brew.
Then
yes.
It was succeeded by Sophia Kufu.
Gloria.
Yes, Gloria Kufu too was.
Gloria came in 2017.
President Nana did not touch my set of clients until the ECOWAS court had finished the decision. You understand? There was a lot of, because there was that, despite the bail and all that, the then Chief Justice and all that, they allowed us to go through the process. You understand? So, for me, as a practitioner, and having been there before, I understand. Look, it's not an easy thing to go through. And when you, the lawyer, are having a judge as your client, it's even a different matter. You have to manage them psychologically. You have to manage their expectations.
This time around, it's not just a judge; it's a Chief Justice.
Exactly. And you remember that time we were fighting.
How can you ever imagine that a Chief Justice can be removed?
Yeah, and then she becomes a client and needs the services of a lawyer. Yes. Look, these were judges who were appearing before. At the time, I was probably about 7 years at the bar. And to sit down and be having the judge edit, you do the work, then you give it to your client, to the judge, you edit it, bring it back to you. You say, no, my lord, we are not writing a judgment. You are doing an argument. So you have to turn it this way. You have to manage them. And then you have to go to court with them I remember one of the things were in the Supreme Court. These were their fellow. Look, it wasn't easy for them. These are their fellow colleagues, and they had to sit and adjudicate in a matter in respect of them. Charlie, the temperature and the tensions I was there. You were there.
Yes,
you know,
I know.
Even it gets to a point
in
where,
fact, the truth of the matter is that the current Chief Justice, she was the one appointed by then Chief Justice.
I didn't want to go. I didn't even want to go in there.
Cases involving the removal of judges.
I didn't want to go in there. You and I know. That's why I said one day we'll write a book. Look, it gets to a point. Even the empaneling. Look, there was one day. Remember, one of the judges was not well, and there was a thought of changing and he had to take an hour's telephone conversation just to maintain the panel as it was, because there was they didn't want this, it looked like there had been any changes. It is not an easy process. So that's why I think that the in-camera thing was meant for whoever the framers were at the time had good reason why they thought everything should be in-camera. But you see, the court is not also bound by its previous decision. So if we have come to the stage where the court may depart, you see, that's why it is important to allow the different stages to be litigated, so that if there is any change, the change would take into account what has happened in the past and what should happen now. So I just urge all the stakeholders to still have belief in the justice system. You see, because Ghana is blessed that we have not had a situation where the judges, for example, have gone on strike and said that until you finish this matter, we are not going to continue with. The justice system is still going on. So let's take out all the politics. Let's take out all the bad name calling and all that. And let's allow the integrity of the process to continue. Because at the end of the day, I think that the Ghana's democracy will be the richer for it if we allow the persons affected and the processes to be litigated. You understand?
Okay, so there's a quick point, and I know Baffour wants to come in, but the quick point about the fact, before you came, lawyer Baffour intimated that, in your case, Justice Paul Derry versus Tiger IPI, the court said that, well, it agrees that Article 146 Clause 8, which is the in-camera part of this thing, has been breached.
Correct.
But the court took the opinion that, in spite of the breach, it still does not in any way, as it were, negate the process.
Of course. If you read the decision of Benning, Benning was clear that, look, in as much as there was a breach of the constitutional precedent, he made reference to Caesar's wife, that Caesar's wife must be above reproach, and said that at the core is an allegation against a judicial officer. If the judiciary cannot hold itself accountable to the highest standards and allow the processes to be investigated, what it does is to cloud public perception about the skills of justice, that the judiciary can be bought, it can be manipulated. So the justices were not prepared to use a technicality to prevent scrutiny of the petitions.
Okay, so based on that, I'm finding out that if the judges at the time could say that in camera breached, but the process must still continue, could that be a strong grounds to say that the Chief Justice is saying that I want this process to be out there?
See, that's why the Supreme Court is not bound by its previous decisions. It can depart. You understand? You remember that in our time we made a novel argument. That was the first time that that was the first time that we had called for the nullification of the petition on the ground of a breach. I think it was in a Jechum, but it wasn't tackled head on. But that's why I took the inspiration to do that particular application, that he had showed pockets of it, and so the whole thing must be the Supreme Court must nullify it. Because at some point, some lawyers or the colleagues of mine said that, look, once he showed it, then I shouldn't go ahead with the Supreme Court case. But when he showed it, that rather strengthened my resolve that he was going to do a national tour and I was going to prevent it. You understand? So that is why I went to the Supreme Court on that particular leg, that even screening it constitutes a breach. But I wanted to nullify the petition. But the court disagreed with me. and then reaffirmed Ajechu by saying that the petition cannot be truncated. So that's where they made the categorical statement that they will not allow the petition to be truncated or the person to be truncated simply because somebody has breached the privacy rules. Now the problem there is, this time around, the subject matter, the person who is affected by the petition is saying that I want to waive that right of in-camera, because primarily it's meant to protect the integrity of the justice concerned. Honestly, that is it's not about the petitioner. It's about the allegations and the office of the judicial officer, so that the person will not be damaged if the allegations are proven to be false. Now, the argument has been flipped on the other side. Now, look, I am the subject matter of the allegations. I say I want it broadcast. Should we still maintain the constitutional provision, or should we interpret it in a manner that says that, okay, if the person who is affected by the what do you call it?
The petition
says that I want it to be broadcast live, then he is waiving a constitutional right. So there's a debate between whether it's a constitutional right as opposed to a constitutional provision that cannot be waived.
Like a constitutional imposition.
A position that cannot be waived. So that intellectual argument must be dealt with by the court.
Okay.
You understand? So first and foremost, I want to congratulate the acting chief justice for at least having these matters heard. You understand? Somebody could have decided that let the process go on, let this matter let the constitutional case take its normal.
But he participating in it has become an issue.
Oh, Bakabo, that one from Akufo-Addo's time till now, Akufo-Addo versus the lot of cases that have said that the principle, that's why we learn the principle of necessity, that it is an exception to the natural justice principle, that where the constitution imposes a duty, it will be override that natural justice requirement. So that one is
all right. So Mr. Jantua is in. I'll come to you, Mr. Jantua, shortly. But Nana, just come in about the comments that Ni has made. Yes.
Okay. So Ni, I get the point about the right of the office holder. I want you to look at the Derry decision. One of the things the court stated, Justice Bain's decision, was to the effect that the Article 1468 is to protect judicial independence.
Yes.
If it is supposed to protect judicial independence, then it may not be limited to the Chief Justice or an office holder alone.
Yeah.
So that it becomes an institutional or organizational right.
Yes.
Okay? Yes. Which the Chief Justice will be benefiting by reason of being part of the judiciary. In that case, if you say you are, the argument may be prejudicial. So let me ask a question.
Yeah.
In that circumstance, in waiving it, are you not also going to affect the general right of the judiciary?
When you look at, I remember in drafting those arguments, I went back to Ajechu, looked at Ajechu and said that, look, that particular provision is meant to start, even where it starts from became an issue in respect of the arguments. That does it start from the formation of the committee envisaged when the prima facie is done, or it starts from the very day the petition is sent in? Because part of the argument from Tiger Eye was that it should be activated.
When you look at the interpretation the court gave it,
correct.
It said we should look at 1468 as a whole.
Correct.
So if you are looking at 1468 as a whole, then it starts from the petition.
Exactly.
Now the question is this: the in-camera hearing. What is the mischief that is supposed to prevent?
That is the philosophical and textual debate.
The philosophical mischief,
yes,
is not really about the person, but the office.
Correct.
Don't forget that when one judge is found to be corrupt,
yes,
the perception then is formed that all judges are corrupt.
Correct.
This is the society we have. And So in protecting the integrity or reputation of a judge, you are protecting the integrity or reputation
correct
of the
whole. I accept that argument. You see,
exactly.
From what I have read from the Chief Justice Tokonu's rate, she is trying to make the argument, and maybe I'm wrong, maybe the lawyers would, but she's trying to make the argument that, look, this particular provision, if you've read the case law and all that, is meant to protect the reputation of the, yes, or you said the office, I agree, but you see, at the end of the day, if you read most of the decisions and the judges who have tried to interpret Article 146, one of the things they keep saying is that if the allegations against the judge turn out to be false, you understand, then the in-camera proceedings protect the justice from perceived and actual allegations of corruption. Because if we play out the allegations in the open, and at the end of the day it is not true, you have damaged the person forever. You know this thing we say about defamation, that once the allegation goes out, it is a certain number of people that hear it. It is not the same number of people that will hear the rejoinder or the apology.
What about if the person involved is saying that I cannot trust that I'll be treated fairly?
That is why the Supreme Court must maybe weigh in and give a decision as to whether it is a personal right that is being enshrined there and which can be waived by the person on a case-by-case basis, or whether they will still uphold Ajetum, Derry, and all the other decisions that have said that in camera is in camera. It is for the entire process.
Your mention of case-by-case basis for me is very interesting, and it looks like that is where the Supreme Court has not been able to do quite often.
Yeah.
Looking forward and prescribing things on a case-by-case basis. And so when you even take decisions, right, it's difficult to even see exceptional circumstances being elaborated. Mm-hmm. Then another case will come up, and the same court will now tell you why it doesn't apply, when it could have done that at the first instance to guide all of us going forward. And so we are in a very difficult situation because of the way things have been done very respectfully by our courts. You appreciate the point I'm making?
I appreciate the point that you're making very, very well.
When the issue of the suspension of the CJ came up, and I said that it was unconstitutional and all that. Yeah. I remember my brother ADG making reference to the case of Bradford France, right? Yes. And subsequently saying that the matter has been settled in Muntier 3. Muntier 3 wasn't a departure from Bradford France.
Okay.
Muntier 3 only applied a principle from Bradford France. You understand?
Okay.
But the Supreme Court, in writing the Muntier 3 decision, you could tell they didn't depart. They were only following Muntier 3. But there's an exception in there with that in a rare situation did for us. What is that? When it is a quasi-judicial situation, when it is an adjudication, you need regulations, right, to govern it. And so all other situations is not so necessary. Okay? Now, what I am saying is that in going forward, when decisions come, we should be very forward-looking to look at situations where some of these decisions may not be applicable and deal with them holistically, comprehensively, so that we are all guided. Unless that is done, we risk suffering judicial arbitrariness. As we sit here, a little digression. What constitutes exceptional circumstances for stay of execution, for stay of proceedings? Not rather. What constitutes it? You understand? They'll say one thing today, they'll say another thing tomorrow. So we are in a very difficult situation because of the approach of our court. I'm saying that this case, the court is a great opportunity for the judiciary itself to protect itself. Look, in all situations, in all democracies, all these things do happen. There's one person that will take the fall for the rest. And that fall will be meaningless unless it leads to the necessary reforms, either legislative reforms or through judicial pronouncements. When you go to a country like England, they do not have a written constitution. But have you even experienced, have you in our lifetime seen chaos in the constitutional democracy of the United Kingdom before? We have never witnessed it. There's orderliness because you see, the court is consistent. The court speaks with one voice. The court speaks from one side, speaks from the same side of its mouth. But in a written constitution, you are always having experience of inconsistency. It's problematic. It's problematic. We can't continue like this. And so, Justice Tokonu may be going through this, but let the court seize the case before them as an opportunity to make a great statement. Oliver Cromwell took umbrage with the conduct of, is it Charles I or Henry I? Is it Charles I?
Yes.
Umbrage with it. Okay? And then there was regicide. Following the regicide, there was a whole gamut of changes, okay, that transformed the English democracy. If we continue with decisions that are convenient for a time and for people, we are not going to make progress in our democracy. And so, for me, Godfrey Dami's case against the Chief Justice Justice Tokono's case, for me, is a very important case. The court can, out of convenience, shy away from making decisions that will be long-standing for the benefit of the future.
Okay, all right. So,
and the court, in the interest of Ghana and prosperity, have a golden opportunity to make a statement. It may not benefit Chief Justice Tokono, but it will protect the judiciary and secure their independence firmly.
Okay, so Nana, thank you for your interesting submissions. Let me just establish that, and Nana, stay with us on the telephone if you can, because I want to pick your thoughts before I let you go on a recent development. But Mr. Kwabe Jantwa is here. Good morning to you, Mr. Jantwa.
Good morning.
Thank you for coming.
Nana, I thought I would see you here. How are you?
I'm very well, thank you, my uncle.
He's in Kumasi.
In Kumasi.
Yes.
I'm in your constituency. Menchia South. He's a Menchia man, even though his father is from Asokwa. He's got his family in Ashdown.
The man knows all your history.
He knows me like nobody else.
Okay, and then my very good friend Oxford Bonsu is also here.
Oxford is my brother.
Yes, Oxford is here. Oxford, good morning.
Good morning.
It's good to see you.
Nice one. And good morning also.
Good morning.
Yeah, so when we get you off the telephone so that you can do other things, Oxford will take over from you and continue with your arguments.
Sure.
But let me bring the two of them in. But Nana, because you have to go, let me deal with this matter. Just yesterday, there was this issue about Adenta Kumi, which came up so loudly. He was picked up from his house. There was rumors that the wife was pregnant and caused the miscarriage and all those kind of stuff. The minority leader, subsequently, we saw images coming from his office showing that he had gone to the BNI or NIB, whatever it is, to get him out and all that. Your quick thoughts on those developments?
It is unfortunate. Very, very unfortunate. It goes back to my argument about developing a progressive democracy. For democracies to progress, you don't intimidate people who speak or file petitions. You allow the system to run, and standards are built, which will guide us moving forward, and that would also serve as a deterrent to others. The moment you arrest people because they filed a petition and so on and so forth, you raise suspicion about you wanting to hide something. The judges involved are people I respect a lot. They are distinguished lawyers, they are distinguished judges, and so they don't need to live with any form of blemish as a result of inconclusive matters that were not dealt with conclusively. And so it is very unfortunate. I've heard certain commentaries in the media, and when I listen to them, I laugh. We need to elevate very respectfully our analysis of issues. That on the basis of a 2-second or 2-minute video, the allegation of the gentleman has been declared frivolous by some people in the media. They laughed. My brother, I've not met the gentleman even though he has spoken to me on the phone, wanting legal guidance. The issue really is that when a person makes an allegation, we should give him the opportunity to prove it. You bring out a video which is about 2 minutes or 20 seconds in length. The question is this: how long did the persons named in the petition who were seen in the video spend at the restaurant? You see, by the video, certain primary facts have been established that the named person indeed and in fact were at the restaurant. And so we need to go beyond that to ascertain whether what the gentleman is saying happened. I don't think that Mr. Tadio went to the restaurant to do any such thing. I don't think that the judges will go to the restaurant and do any such thing. However, there's an allegation that has been made. Allegation, when it happened, I wasn't there. So we need to give the person that made the allegation the opportunity to prove them. When you look at the video, the judges had just walked in. But the video doesn't show when the judges walked out what happened during the time that the judges were in the restaurant. Right? We saw that Mr. Tadio actually hugged them, which is what every lawyer would do. I wouldn't see Justice Kolendi in a restaurant and say, I will not go to him and greet him, even though I've got a lot of cases pending at the Supreme Court. I wouldn't say I will see Justice Tanko Opamai and wouldn't go to them. No, I wouldn't say that. But the gentleman makes some allegations, and you bring out a 2-second or 20-second video that does not show activities for the time that they were in the restaurant. And people are saying that on the basis of that, this video should, on the basis of the video, the petition is frivolous. My brother, I can imagine if they are defense counsels in a matter of murder or rape or defilement like you and I did some time ago, Wilberforce, I can imagine how many people will be jailed on the basis of that. I can imagine how many people will be jailed if they were counsels in a matter on the basis of that. Now, on the strength of a video, 20 seconds video, who goes into a restaurant for 20 seconds? Who goes? The period for the waiting time for food, order for food, it goes beyond 20 seconds. And during that period, what happened? The video doesn't show. There were persons in the restaurant. Evidence is not just video. Evidence is also about the persons in the restaurant, what they witnessed, right? This person may have people who will be there to testify. What does the video show? It doesn't show all these things. And so when I've heard people in the media do analysis and say that the petition should be dismissed merely on the video that has been put out, I find it very unfortunate. I think that we need more. We need more than that. And I believe that if there was more than that in the media, if there was more than that in the media, then we cannot come to the conclusion that a frivolous petition that should not be given the necessary attention.
In other words, yes,
I may say, on the strength of what I know, that Justice Tadio is a gentleman, very principled man. So the things that are being said about him cannot be done, and it is not true. If it is just me, Baffour alone, if it is just I, Baffour alone, speaking on these matters, I will dismiss them because I know the people in question. I know that they are people of proven integrity, disciplined and principled people. However, it is not Baffour. It is Adenta Kumi that is making the allegation. And I don't think that he should not be given his day in the absence of further evidence in the public domain.
Okay, all right. So, very, very interesting thoughts there being shared by lawyer Nana Baffour-Awuah there. But there's some thoughts here that people are sharing, and I'll come to those who are in the studio. Nana, if you can still stay with us, that would be lovely, because I know you have so many things to do.
I beg you, I need to go first now.
Yes, I can imagine. Yes.
Next weekend, by the grace of God, I'll be in Accra.
Yes. So we are signing you off, and we want to thank you for the beautiful thoughts you have shared with us today. I think you have engaged.
I'm grateful for the opportunity.
Yes, engaged in a lot of.
If you had not given me the opportunity, I wouldn't have had the opportunity. I wouldn't have been able to share them.
Yes.
So I'm grateful to you.
Anytime.
My regards to my friends in the studio.
Exactly.
All right. To see you.
Bye.
Yes. So thank you.
Bye.
Thank you very much. All right. So let me come to the studio, and just to let everybody know that we are on ABC television, and Jimmy Ebo Grant in Takrady says that good morning, bro, and glad now watching the forum again on ABC TV network. It's been long time. Please tell my senior Mani to be cool. All right, and so that is Ebo Grant from Takrady. Ebo, thank you for your message. And then on Facebook, we have Christopher Abe, who says that good morning, Wilby, and your respected panel. I really believe there is no legal argument that will make legal sense and get the current Supreme Court justices under the NDC acting CJ to think otherwise. It is unfortunate, but the CJ is not coming back. Just look at the lawyers for the petitioners. The whole thing was cooked at the NDC headquarters and activated when the NDC won the elections. The Chief Justice should fight if she wants, but she is not coming back. And that is Christopher. Christopher says again that what does he say again? He says there are too many personal and party interests in Ghana. President Mahama really wants to leave a good legacy. It is very clear for everyone to see, but this one particular move against the CJ will follow him forever, especially if, as suspected, they end up sacking her. Politicians don't learn. And my co-host, Abdul Basit Mahama, is here. He says that Rich versus Baldwin, 1964, AC 40, UK House of Lords principle. A decision maker must give the affected person a chance to be heard, even at a preliminary decision stage. Failing which the decision is void for breach of natural justice. A defective determination ought to be corrected because due process is not a favor, it is a right. And that is Abdul Basit Muhammad's message. And then there's Gibson, who says that, good morning, Wilberforce. What an intellectual discussion. The forum, the legal luminary platform. Thank you very much, Gibson, for your recommendation and commendation, if I can say so. Samuel Ofosuba says that, good morning, Wilberforce. Sorry, your noble panelists. It says that my good friend Nick Bako Samuel Ado and Nana Eje Baffour-Awuah, all actions and precedents concerning the suspended leadership Chief Justice Gertrude Araba Sakitokonu are exposing the cooked and arranged planning from the NDC and the Mahama administration to expunge her. As regards such, no amount of knocks provided by the legal team for her will be accepted by the acting Chief Justice's team. But it is good that her leadership, Gertrude Araba Sakitokonu, fights her way to the end. Okay, so some people endorsing a fight. The value of the judiciary is dominated. It says that the value of the judiciary is dominated in its own currency. The currency is public trust. How much of it has been spent on this case? And so, yes, a very good question being asked there by Abdul Basit Mama when it comes to public trust as far as the judiciary is concerned. I have the last message I'll read before I come back to the studio. Asante Isaac, who says that, good morning, Wilberforce. For me, the attempt to remove the CJ is deep-seated, well orchestrated, and brewed in from the umbrella chamber. So the whole process is tainted with lack of integrity and predetermined. The CJ is gone. The public just wants to know what happened. And that is a comment by Asante Isaac there. Let me come to the studio, and I will start with Ms. Jantua, and then I'll come to you, Oxford. So, Ms. Jantua, the position now is that the CJ says, this whole process is about me. The Constitution says something should happen in camera. The discussions we have had with the two lawyers is suggesting that, well, it's in camera, but in the previous case, in the Anas Paul Derry case, the in-camera issue was breached. But the court says that irrespective of the breach, it does not negate the process. So some are saying that if the court can say that in-camera is breached, but the actual process should continue irrespective of the breach, then why can't the same court say that, okay, the person affected says that, I want you to waive that so that everybody sees, because I think I have a defense. I want everybody to see when I put up my defense so that it will be clear. Shouldn't that be something that the court should be thinking about? No, my question is not difficult. It's not. I'm just drawing your attention.
Oxford is even laughing.
Oh, you're laughing at my question. So I didn't ask a proper question.
Condescending, whining.
No, I'm not whining. I'm just trying to lay a preamble because people are listening. They must understand why we're asking the question.
Good morning to our viewers.
Yes.
Good morning to our Facebook panel. Wilberforce. The Supreme Court is a master of its own decisions, isn't it? They can decide to take a decision they made some time back on a particular case, and they can decide to ignore it and go a certain direction.
The Constitution actually says that they can depart from their previous decisions.
They can. So that bit that you referred to is up to the Supreme Court to decide which way they want to go. But when you come to 1478, this is an argument I've been
146 or 147.
146.
Yes.
8. This is an argument I've been making all week. The bit that talks about, and remember, 146 is specific to the judiciary. Specific to the judiciary. And 1468, the bit where it says, all proceedings under this article shall be held in camera. In camera is written in italics. It goes to show the importance of the in camera. It is not printed in bold as the other prints in that particular clause. That should tell you something. And the case you referred to, Anas, and the case you're referring to now with the Supreme Court judge, the CJ, this is somebody who is part and parcel of that fabric. Part and parcel of that fabric. It is her colleagues who are going to do what? Judge her. And in order, and for me, what I understand by this bit of in camera, in order to preserve the sanctity of the judiciary, I believe that the framers of the Constitution decided to put this, an emphasis on clause 8 in the in camera in italics. Look, I would want a situation where all this rigmarole isn't there. The best thing for the CJ is to have a strong defense, evidence, watertight evidence. Make sure that if she is not defending herself and lawyers are defending her, they can make their case, watertight case. And you know something? Although, and this is Ghana, although we are saying this should be held in camera, 8 Article 146 is specific to the judiciary. Are you trying to tell me, Wilberforce, you are a journalist, and a good journalist at that, a journalist who always is seeking for information? Are you trying to tell me the proceedings won't leak? You're trying to tell me? Are you trying to tell me that the in-camera here is so subjective that nothing could come out? The proceedings would leak. No two ways about it. As to how it leaks, that I can't tell. But definitely, certain parts of the proceedings, if you're not even careful, everything that would go on there would be in the general public. Now, I would have wished.
So should we prevent that by making it public? The leakage. Why allow leakage when you can actually give an order and make it public?
There is law. The Constitution states in camera. You see, and I said this last week, one thing that we don't do well in this country is where we always bring personalities before the law. Look at personalities who have had cases. We always bring and we always try to make way for personalities instead of the law. The law comes first, irrespective of what kind of personality you are. It has to come first. And the main law of the land, the Constitution, has stated it has to be held in camera. Look, I said this week that the CJ's petition should not have gone to the Supreme Court.
No, her application, that's sent to the court.
Yes,
Okay.
it should not have gone to the Supreme Court.
Where should it have
gone to the president? Who suspended her? Wasn't it the president through the process in the Constitution? When you go to same Article 146, Clause 11, and let me read it for you. Clause 11 states, the president may at any time revoke a suspension under this article. He has the power of revoking the suspension. So if her arguments were sent directly to the president, the operative word there, may, he could read it. It doesn't also say that with this particular clause. It doesn't say he has to consult Council of State, he has to consult lawyers. It is specific to him. Discretion. He has the entire discretion.
But when it comes to issues of constitutional interpretation and constitutional issues, the president cannot give interpretation to the Constitution. It has to be the Supreme Court.
I'm saying. 11. In as much as you've said that, 11 gives him power, doesn't it?
Yes, but that is to suspend the suspension.
Yeah, to revoke. The word is revoke,
yes.
not suspend.
Yes.
Revoke a suspension. What is she asking for? Is she not asking the suspension to be revoked? Is she not asking for that?
Well, yes, but
it's not asking, It's not well. Yes.
Oh yeah, but I'm saying she's asking for that, but she's asking. It's like the president has taken a decision based on a warrant. So you are saying that she go to the president and tell the president, please suspend or revoke the suspension.
Yes. Why? Hasn't she gone to the Supreme Court? She wants interpretation from the Supreme Court. Was it the Supreme Court who suspended her?
There's a lawyer here, so he'll help us.
Well, I'm not a lawyer. That's why I'm not. Me too. Yeah, so me too. I'm looking at that. I'm looking at that bit. That is the basis of my argument.
Yes.
My good brother's argument. I've just realized he's my relative. I didn't know. I just realized today that he's my relative.
Okay.
Everybody
is your relative.
I don't know. You see, my family is big. My family is very big, both on my father and my mother's side. My father's grandfather had, my father's father had 70 children. So you can imagine.
Oh, yeah?
Yes.
Your father was one of the 70?
Yes, one of the 70. They were a set of 5 brothers. And they are set like that.
And they are all called Jantua?
They are all called Jantua.
Hey.
Yes. The man was a rich man, so he could fool around.
That is scary.
Well. So my argument is that it should have. And yes, the president, if it had gone to him, I'm sure he would have gone back to the Council of State. Because the prima facie case was done what? Was brought up by the Council of State. I would want a situation where my good friend CJ would just go ahead and argue her case. Because whatever the case is, we will get to hear what happened. We will get to hear how the judges on the committee reacted and made their case too. So, for me, in as much as this rigmarole is going on, isn't the committee hearing it? Has it stopped the committee? It hasn't. It could happen. It could happen either way. She can be vindicated or she could be found guilty. And if she's vindicated, what would all the rigmarole we are going on for before? Yes, if she's found guilty, the committee would give reasons why. And those reasons should be cogent. You see, one thing that is sad, would you agree with me that this is a legal issue? Will you agree with me that this is a legal issue?
When you the entire Chief Justice process,
yes,
so there's a very much a legal aspect of it, but I also think there's a political aspect of it.
But the political aspect has taken over. The political aspect has taken over. If this were any developed country, it would stay in that legal frame. But the political aspect has been taken over, and that political aspect that's been taken over stems from politicians and stems from history. Do you know the only time a CJ was uprooted from their position was in the Nkrumah government? That's the only time. That was the only time. So let's see how this process goes. And for me, I believe if her case is cogent, if her evidence is strong, no jack can remove her. If she comes out where she is being validated and found not to be guilty, who can move her? Nobody can move her. So let's even take it that is the process of the NDC who are because the petition was put in by what? A citizen of the country. That citizen of the country can either be a member of the CPP, a member or support the NDC, support the MPP. It could be any of them, because in Ghana, everybody of sound mind and a certain age votes. And you cannot say because the person votes for a particular party, it is the party that has triggered it and made it happen. Yes, commentary has come up from members of the NDC, but is that commentary? Is that what we're looking at? Is the commentary what we should use to say that yes, the CJ would be moved? Let's use the facts of the case. Let's use the evidence that will be brought up during the committee hearing.
Okay, so
and then let's see how it pans out.
So, Mr. Jantua, just before I come to you, Oxford, so Abdul Basit Mahama is saying something here that I agree with, and I want to pick your thoughts on it. He's saying that why do all the doors to challenge this process seem locked from the inside? Now, he's saying this because if you look at all the processes thus far which has gone on, it appears that the doors have actually been locked from the inside, and people are inside and they've locked the door. So if you are outside, you can't enter.
Give me
So what he's trying to say is that so far since this CJ issue came up, she had to request for a response, for the petitions to be brought to her so that she responds to them, because an announcement was made to the public without recourse to her. So she was not giving the opportunity to even respond to these petitions before it became public knowledge. It became public knowledge, then she had to now request for it. Then her request was it was sent to her, and she was given a timeline to respond. She responded within that timeline. Then it went to Council of State. Cases have gone to the court. It looks like there's a division. In the first case, it was a 3-2 majority decision, 2 people in the Supreme Court. And we are going to discuss the ruling of the Supreme Court, because there are some elements that we should talk about and all that. So it's suggesting that the door is locked to the Chief Justice. It doesn't seem like that to you?
You were saying that she hit blockages within the process. But Wilberforce, educate me. What is the process supposed to be when the Council of State can declare a prima facie case, should she be given the opportunity to first of all defend herself that way? Because I thought that it's at the committee stage that she has to bring her case and evidence, or she's supposed to defend herself by some kind petition to what?
So, Mr. Jantua, notice that there's a petition.
Yes.
The petition is forwarded to the CJ.
Yes.
She has responded to the petition.
Yes.
In terms of all of it, and I have it here. I have all her responses.
Yes.
We can read them. This is a long read.
Yes.
So
I have it too.
Yes, her position on the allegations against her are known.
Yes.
Both to the president, to the Council of State,
yes,
and then also to the committee.
Yes.
What the expectation is that if, in spite of her response,
when you say also to the committee hasn't sat.
Yes,
so
but
you
the
are assuming that the committee is aware of it. They haven't sat.
No, so the committee sits on the basis of all the documentations that have taken
yes,
place that are forwarded to them.
Yes.
So the committee is seized with the petition.
Yes.
And is seized with her responses.
Yes.
Irrespective of that, they are saying that they have established a prima facie case,
yes,
which is the president and the Council of State.
Yes.
And so she has a case. So when she goes to this
the Council of State and the president, not the other way around.
Yes.
Yes.
So when they go to the committee,
yes,
what it means is that at that point they are supposed to present the Chief Justice with the prima facie that has been established.
Yes.
Because it is the prima facie
yes,
that she's going to respond to.
Yes.
So if she says that I have not been given anything about the prima facie,
yes,
so what am I responding to?
But she has lawyers, doesn't she? wait, hold on. She has lawyers who should go and inquire for what that prima facie case is and come back with it for her to be able to respond. Look, irrespective of the fact that she's a learned individual, if it so happened that she was defending herself, then maybe yes. But because she has lawyers, it's the responsibility of the lawyers to get all the necessary documentation for them to be able to make their case. So if the prima facie reason hasn't been given the lawyers, then that's an aberration.
Okay, so let me come to Oxford. And just as I come to you, there are some messages here. Let me just read them and then we can come to you. So there is a message here from Abe who says, seriously, the country needs to move on from this CJ thing and know that the next government will also sack whoever the NDC appoints as CJ. You come into power with your CJ, pardon all your party people from criminal cases. Then when you are voted against, you go out and the whole process is repeated again. What a country. And that is Abe's message. You might think that it's funny, but it is a very disturbing comment. If you ask me.
It is.
Yes, it's not a bad comment from him.
Yes,
but the content of it is very
disturbing.
It's very disturbing.
And this is what we should be looking at.
Yes.
Because we tend to repeat ourselves all the time. Yes. Look through the Fourth Republic. Some of these things have just repeated, and we are not learning from it.
Yes.
And it doesn't help us.
Okay, so
we can't build a nation that way.
Mr. Ofosuba is coming into the conversation and he says that, Wilberforce, I plead with you, get some astute and good lawyer luminaries with a political mindset in respect of the well-being of the law, like respected Nick Papo and Nana J. Baffour and their kind, to come and educate us on this respected CJ's dismissal. Most of us who don't know much about the legalities of the case are really confused. Okay, so they were here, and I believe that you listen to them. They are still very good ones here. You are going to hear Oxford very soon. When you hear him, you know that he's also a very good lawyer, just like Mr. Jantua has shared his thoughts with us this morning. Okay, so Senior, your question is a valid concern. Okay, so that is somebody responding to a question that was asked by someone. Okay, all right. So let me read the last message and then I come to you, Oxford. So I think the NDC should cease this premeditated persecution of the CJ as it's increasingly affecting the image of Ghana's budding democracy. Again, those who are seeking... Okay, so I keep getting messages, and so I have to hold the message so that I'll be able to read the one I'm reading as at the time I'm here. Okay, so when I don't hold it, then I lose it. Okay, so again, those who are seeking her removal are even flouting the same constitutional principles every blessed day. The country's judiciary is gradually becoming a joke among the international community. Okay, so Haruna Al-Hassan also has a message, and he says that Haruna, where are you? Okay, so Haruna says that okay, that's a very long one. He says that he's from Tamale. Good morning to you and to your panelists. In fact, Mr. President, please stop your people from doing such ridiculous and shambolic work of chasing people at their places as if we are under the military regime. This is not what Ghanaians voted for. MPP would have loved to be in power. You'd think that they want to lose power. When they lose power, you think that it is your power, your strength, or your intellect that made you win the elections. Okay, so it goes on and on and on. I'm unable to read all of it. Abdul Basit Mahama says that the AG, the acting CJ, may have a vested interest. My argument: can an acting CJ who stands to benefit from the continued suspension of the substantive Chief Justice truly be seen as impartial when presiding over cases challenging that very suspension? And that is a question intellectually asked by my intellectual friend Mahama. Okay, so Wilberforce, the sad truth is that this country is treading on a slippery slope. And last message, may I pose to ask this question. So if at that particular moment in time at the restaurant, Justice Tokonu had also walked in, what would have happened? And that's Edwin's message. Okay, Oxford, sorry for keeping you waiting for all this while, because these messages are very important. The constituency, Facebook constituency. But your thoughts on us? The TJ says that he wants the whole process heard on camera instead of in camera.
All right, thank you very much. I think we've heard a lot from our Facebook community. And so we want to say good morning to all of them and everyone listening.
And we are also on ABC Television.
ABC Television,
yes.
That's good. You see, this whole processing is very exhaustive. And I can only imagine what the CJ is actually going through. And so we've had a lot of applications that might even seem to be abuse of court processes, but to have her own also come on top of that. Now, first of all, she want the whole processes in camera. No, in public. Yes, but the process is supposed to be, as per the provisions in the Constitution, supposed to be in camera. So we want to ask the question, what can that provision be done, or who can change or make any changes to that provision? First of all, it's an express provision that this whole process must be done this way. And then the whole Article 146 is conjunctive, that every part of the provision coming from Clause 1 is all joined together. And I remember when Mr. Jantua even read a very interesting provision, Clause 11. Now, what will happen in court when we actually go to court? What should be the orders that will come from the court? Are we envisaging that the court will give an order contrary to what is, what is provided for in this provision? It's going to be a very difficult, to me, if you ask me, it's going to be a very difficult ask. But in any case, now we know that this process is supposed to be a legal process. So everything that we are going to talk about should be matters of the law. And at the point that there are controversy, we go to court for interpretation.
Mm-hmm.
Now, the very limited part that is political, and that political aspect of it can be demonstrated by the president alone, because the duty, upon the president to act. And the president is actually acting. You go to the ruling that came from Vincent case, and you realize what the court is saying about stopping the duties of a constitutional duty of the president. So I don't believe we'll be able to make any changes concerning this provision here. But as Mr. Jantua said, could that be the case that we could make a petition, a counter petition to the president that, because all cases that were heard in public in Supreme Court were applications or requests that actually the Attorney General made. So we could actually also make a request to the president that we want this situation. Don't forget that there was a reason for putting this provision in the Constitution. And the reason behind the provision is to protect the dignity of the judiciary. And here we are not talking about Justice Tokunu, we're talking about the office of the Chief Justice.
Exactly.
Everything we do
Yes.
affect the office.
Yes.
Forget about the person.
Yes.
So I remember you read a comment that somebody said, we've locked the key to all. I don't know how he put it.
He says that it looks like all the keys to this case have been locked.
Yes.
And the Chief Justice.
Yes,
I'm just trying to find it. Yes. Okay. So he said, why do all the doors to challenge this process seem locked from the inside?
It's locked.
Yes. That was
Very
Abdul Basit
interesting.
Mohammed's
Yes.
message. Yes.
A very interesting comment he made there. It's locked. Locked. I wanted to ask him who locked the doors. And kept
Well,
the
he's
key.
listening, so he will send
Yes.
the message. Trust me.
It's locked. And it will be sad to know the person who actually locked the door first. I said it, I think, on one of your sister platform, I think around 4th April, that it was very unfortunate. I say unfortunate because where it was a right that Chief Justice wanted to actually demonstrate, it was unfortunate that she asked or requested for the petition to be sent to her. Because if she had not requested for the petition, all the application to the court would have taken a different form. So we would have gained a real opportunity to learn and to give the majority bench to interpret every provision for us to understand. Because we make reference to the Ajetum case. That even made reference to the fact that when we talk about removal of the Chief Justice, the office is first a justice before being the Chief Justice.
Yes.
In that case, if removal of any of the justice of the Superior Court warrant prima facie case, therefore we also have to establish. But that case couldn't even give any framework how to establish
As to who does it.
Yes. So this would have been a real case for us to hear what the court would actually, maybe they would have come with some modality how to establish the prima facie case. But we lost it. How? Because of how we started the whole application. So probably that's the reason for he saying that we flood the doors within. But as coming back to the provision in the 1468, so I believe we have to protect the dignity of the office. But again, we could have also made a request which would have been granted by the president for exercising his power. I believe some of the application, because we shouldn't overshadow the legal implications with our politics. If we do that, we will lost in all this thing.
Secure the case.
Because some social, civil society would have also gone on at clause 11 to petition the president. The president, yes, of course, we believe that you are exercising your constitutional right. But because of circumstances, the situation that we are in now, can we reconsider? Because you also have another power. It is here expressly
to revoke.
Revoke it. It's not a court to tell the president to revoke here. There is no controversy about this provision to go for interpretation to do this. And then again, we make reference to the fact that I think Justice Derrick case, they breached this provision, as you were saying.
1468, yes.
In this recent, Asifwa case, Professor Justice Mensah Bonsu said that once the fact that one president made a mistake, not especially about this, but where there was an argument that the federal government received a petition that never asked for a response from the petitioner. She said that if one president make a mistake, we don't expect another president to make a different mistake. It doesn't.
To come and repeat the mistake and justify the mistake.
Justify the mistake. So we have to look at the expert provisions of the Constitution and make meaning out of that. Those that don't create any contention, we don't need to put any contention on it, and make sure that it works differently. And so my point is that it will be hard. But I know that doesn't stop her from exercising her rights. Going there, we don't know what will change. We can't preempt anything. Something can change. As you mentioned, that even the Constitution allows that certain ruling made by the Superior Court can be set aside by themselves. So we will see what will happen. With 3-2 is close for anything to happen there. But the point is that, like I said, if you really believe that you want to make or challenge a process, you allow the process, because evidence that you send to court to make your case. So, for instance, which Professor Mensah Bones will also make emphasize to it. For instance, if you never, or the president refused to send the petition to the Chief Justice, which we believe that in the spirit of a constitution, that is supposed to be the process, then we can go to court. After they have constituted the committee and the committee is in process working, then we can go to court and say that for the fact that it wasn't sent to her, it means that they breached a process. But here's the case that the court in the majority ruling said that the person involved compromise or waive the same process. So they said that if, for instance, the process per se was to be, which is not even written, was that the person supposed to receive the petition, then send the petition to the Chief Justice, for the Chief Justice to respond. And so in that process, they are establishing the prima facie case. The court said that for the fact that the Chief Justice herself requested for the petition, she waived it.
She waived what?
She waived the process. So she waived the wait, because the point is that all this process doesn't even have timeline. So probably you were sitting there, the president would have even sent it anyways. But then because you, in your own volition, decided that, okay, let me write to the president that, no, I've heard this.
But wasn't it because the CJ was sitting in her office and heard that there's a statement released from the presidency?
Yes.
That I have started a process about petitions I've received for your removal.
Yes.
Without the CJ knowing.
Yes.
So will she sit down and fold her arms and say, hey, I've heard that on the media, everybody is talking about the fact that there's a process to remove me. Shouldn't it have been the other way around, that when the president received the petition, before coming to the public to tell the entire country that I am starting a process for the removal, that petitions would have been sent to the CJ, so the CJ would be aware of it and might have even responded. And all that process should actually even be in camera. So the president coming out to make an announcement that I have kick-started a process shouldn't have even been made at all, if we are respecting the principle of in camera.
Yes.
So if you made that, then it means that the one who started the process of waiving the secret nature of this process was actually the president and not the CJ.
So all the provisions, when you go to court, it depends on the grounds you are bringing your action, what you want the court to look at. You understand? In fact, even when the first application went to court, the CJ wasn't even suspended, but they made amendment at a point in time when the action actually happened. But the point the court was making is this: now we know that your right is in the provisions stated in 146 that when the president receives the petition, the president is supposed to send a copy to you. That is the process. Do you understand that? And so if you want to bring an action to court and to say that it was unconstitutional for the president to have received the petition and went to the market or to the public to talk about it.
But that is not one of the reliefs the CJ is seeking.
No, I'm not talking about this.
Okay.
I'm really talking about the ruling from the Vicent case.
Okay.
I'm really making reference to the Vicent case because that would have been the basis for us to even add more application or petition to the court. You understand? But I'm saying that the court is saying that if you are saying we need to even injunct the committee action or the committee work, on what basis are we injuncting it? And for you to say that, okay, one of the reasons is that because the president did not send the petition to the Chief Justice. And here's the case. The opposing affidavit from the AG says that, at a point in time, the CJ herself requested for it and was given. And she actually said
so you are talking about the lead opinion written by Amadou Tanko,
yes.
isn't it? Yes.
Okay. Yes. So they are saying that for the fact that you requested for it, you waive that process. So you even made the process easier for the president. So you can't come back to say that the president faulted on that process.
Wilberforce, are you saying that out of respect for the office of the CJ, the president should have told her or informed her first before coming to the general public to discuss? Is that what you're saying?
So what I'm suggesting is that the general public, in terms of these provisions in Article 146, is not supposed to be part of this process at all, from start to end.
Okay, so the in-camera, when does the in-camera start?
So that is a very good question, and the lawyers have been debating it and are asking that, does the in-camera start when the petition is sent to the president, or does the in-camera start when the president forms a committee to investigate? The lawyers are saying that the in-camera, as far as they are concerned, starts it because the provisions in the Constitution says that the clause 8,
all proceedings. So wait, so you're saying all proceedings starts from the time
a petition is received.
Once the petition is received, and the process going to the Council of State, Council of States recommending whatever to the president. The president now put out the committee. All of that should be in camera.
In camera.
That is the understanding.
Yes.
Is that the understanding?
Yes.
And the proceedings isn't the committee sitting with the Chief Justice and asking her the question.
So yes, the lawyers are suggesting that committee sitting is part of the process. That you cannot in good faith, when you are interpreting the whole Article 146, start from a particular place and leave another. They are saying that if you want to give a fair interpretation of Article 146, then you start interpreting it right from Article 146 1.
If that is the case, why wasn't this particular clause be the first clause in this article to cover the entire thing? Because there will be prosecution and defense arguments. Those who feel what you're saying is right will say that should have been the process. Those who feel the proceedings would be the time they are sitting with the Chief Justice and asking the questions and putting the prima facie case is where the in-camera comes in. So maybe at this point it's up to the Supreme Court to clarify what in-camera means and all proceedings. Then we'll be able to identify whether it covers the entire act or it covers.
So maybe they have the opportunity in this CJ case
Very good.
to do that.
So that is why I said that it's relevant for the CJ case now. So because the other aspect of all this communication that haven't come out clearly. So when we go there, we will have interpretation on this, and so we will understand what the in-camera meant here. Then we can all abide by it. Yes.
Okay.
But you know the good thing? Cases that are coming up, in fact, cases that have come up in this Fourth Republic, especially where the Supreme Court is concerned, is giving Ghanaians the opportunity to get to know the Constitution more.
Yes.
And I think that is very positive. Very, very positive. Look at our Facebook constituency. Some of the quotations they make, some of the arguments they make where the Constitution is concerned. And I think it's a positive thing.
The education is ongoing.
Education is ongoing. I think it's a positive thing.
I agree with you.
Yes.
I agree with you. Okay, so I'm going to get us to discuss some things in the Vincent Assefuah ruling, and I'm going to just pick and then we discuss it shortly. But let me get these messages read for now. So someone posed the question, and none of you have answered the question. Edwin's question: may I pose to ask this question? So if at a particular moment in time at the restaurant, Justice Tokonu had also walked in, what would have happened? And this is a question that you guys must answer. I don't know if you can answer it. Okay. Should a judge who has previously ruled that the president acted lawfully in suspending the CJ be allowed to sit on the Article 146 Investigations Committee examining the same matter? Well, if that happened, then that judge is stopped. I think you are talking about Justice Samuel Esiedu. So he was appointed to the panel. The day the panel was supposed to sit, he called in sick. So the 4-member panel sat without him. And so he would have been the 5th member of the panel. But so he was sick, he didn't come. By the following week, the CJ had been suspended. The acting CJ reconstituted the panel and didn't add Justice Esiedu to the panel. So when that panel came, it was this panel that included Justice Henrietta Mensah Bonsu and Justice Enes Gau, together with Yoni Kolendi, Amadou Tanko, and the acting Chief Justice, Justice Baffour-Awuah. And they took the decision which has resulted in this Vincent Assefuah ruling. So yes, he I don't know what, he was part of the initial panel, but he called in sick that day. And some are saying that probably he had been told by from the grapevine that he was going to be part of the committee.
You don't believe he's sick. You don't believe he's sick. Eh?
All right. All right. So, Wilberforce, greetings from the UK. I think, judging from the way the matter has already been spilled into the public domain, it's only fair that the hearing is televised for all to see. The government is for the people and by the people. So, in my honest opinion, I think the presidency erred in the first place by putting the CJ's issue in the public domain in the first place. And that is Nana Owusu from the UK. Nana, thank you for your message. I think he didn't finish, so he continued again and said, again, judging from the above, the in-camera hearing and the recent restaurant incident regarding the members of that 5-member committee make it a non-starter. The hearing must be televised. Simpliciter. And that is Nana Owusu's message. Okay, some people agree with you, Nana. I believe they are listening. Okay, so Lee Tekpo says that if the CJ got removed, any CJ that they would bring will be seen as NDC CJ. This is a fact, and no matter how fair the CJ will be, still people will tag that person as NDC CJ. We have destroyed all our institutions with politics, and that is Lee Tekpo. Lee, I think I agree with you totally. And I thank you for sending your message. Okay, so Benjamin Elijah Ano says that, in my opinion, and I like the fact that people are sharing their opinions. In my opinion, the Chief Justice has shot herself in the foot for allowing Godfrey Dame to represent her at ongoing trial. Televising the ongoing trial is unnecessarily unnecessary. Okay. Prudence is more important in unlocking the spirit and the letter of the Constitution. The Chief Justice cannot ask people elected by the President to sit on the inquiry to recuse themselves. It's quite bizarre. Are there bad blood between the 2 justices and the Chief Justice because of how partisan she reduced the judiciary to? Or it's just a normal procedure to defend her integrity? Well, you are asking very interesting questions that probably you should be able to answer for yourself. But I don't think that the Chief Justice is saying that she has any bad blood with any of the people on the Supreme Court. All she's asking is that she thinks there's a process ongoing about her, and she thinks it should be made public. It will be in her interest and in the interest of the public itself to make the matters public. In terms of his representation, Godfrey Dame is a lawyer in private practice as we speak today, and so he can be called upon to take care of any brief. He has served as AG before, but he's no longer AG. He's a lawyer in private practice working at Dame and Partners. Okay, what about, okay, so let me read this last message. The keys to those locked doors are being deposited in the Jubilee House. So you asked that question, and that is Samuel Ofosu-Bar's message in response. He says that it is alleged. So he says that the doors have been locked, but allegedly the keys are being kept at the Jubilee House. So if you want to open those doors, You have to go to Jubilee House and get the keys. Okay, so Abdul Basit Mahama, my good friend, again says that that's the current handling of. He says that's the current handling of the CJ suspension and related actions give credence to concerns about judicial complicity in executive outreach. The bench must be very concerned about this reputation collectively and individually. Well, yes, I think they should. And he says that Jantua will never see anything wrong with this president and the NDC. Okay, so I'm not sure there's anything about hypocrisy here. Mr. Jantua, the in-camera process starts from day one, judging from the initial administration, but yet confidential nature of these petitions. This has been too politicized to the extent that the matter is gradually becoming a joke by the day. So Nana thinks that the process of in-camera should be from the beginning.
Let me ask the question. When the petition was sent to the presidency, do the people have the right to know?
Which people?
The people.
Public.
The public.
Oh, okay, you have to the public.
Do they have a right to know?
Well, it's subjective.
It's not well. Do they have a right to know? If we're saying in-camera starts from the day the petition got there, do they have a right to know?
Well, so yes, assuming that the answer to that question you're asking is yes. So if the people have the right to know, yes, I'm saying that I'm assuming that the answer is yes. So if the people have the right to know from the beginning, then they have the right to know throughout the process.
Simple. Simplicity.
Yes. So it means that
if we're saying in-camera starts from the moment the petition hits the president's desk, the president then doesn't have the right to inform the people because it's in-camera till the process continues and he gets to wherever. But the president is a servant to the people and responsible to the people. Every president, not only John Mahama, every president. And are we saying he needs to use discretion to decide whether he tells the people or not? So let's say, you journalist, in camera starts from the day it hits the president's desk, and you, Wilberforce, get to hear that some petition has gone to the president. Will you not come to Asase and discuss it and ask questions of the president and ask questions of everybody? Will that not expose it? Will it not be the same Ghanaians who say, but Mr. President, if a petition has come, why aren't you telling us? Forgetting the law says in camera. So when somebody says, I won't defend, I would always defend the president. It's not a question of defend. It's a question of whether what is in the law has been implemented the right way. As we sit here, we are arguing about what in camera is and where it starts from. If it starts from the time the petition hits the table of the president, then it was ultra vires for the president to say anything. But if it doesn't start from there, then he has the right to inform the people. And my out of the two, I would take the right to inform the people. You are there to serve the people. People need to know. Let me take it in a different light. The president is the commander of what? The Ghana Armed Forces.
Commander-in-Chief.
Commander-in-Chief of Ghana Armed Forces. If they get some intelligence that a country is planning to attack Ghana, would you say with that the president should come and tell the people? No, at that point. They should do all their intelligence, get to know all the ramifications of it, and when we're getting to a point where they have got the intelligence to say that it is true, then they put the people on. But
Mr. Jantua, I'll come to you, Oxford, to ask you. But Mr. Jantua, you are aware that if this petition were against a justice of the Supreme Court, the process is that the president receives it. He acts as a conveying belt, conveys it to the CJ. The CJ conveys it to the judge and say respond. The CJ goes through the process, sets up a committee, investigates, and all of this will not be made public. If it was about a justice of the High Court, for example, when the issues about we've had 2 removals of persons who were subject to the benefits of a Court of Appeal judge, so Charlotte Osei, and then also the woman who was at Shraj, I've forgotten her name. She was also removed. The 2 of them committees were formed and all that. Petitions were received. They went through the process. Even the committee that investigated Charlotte Osei's case, we do not know the members of the committee as we speak today. And that is because you want to protect the dignity of the people and the judiciary. So the judges who adjudicated that matter, as it stands today, we don't know them. The only people who know them are those who appeared before them. So if we are going to know, it has to come from Charlotte Osei and her lawyers, or from the people who were part of the committee themselves. So I'm just saying is that this in-camera thing, we have seen it happen before, and it was start to end. Do you know those who petitioned for the removal of Charlotte Osei? Do you know? No. But we know those who petitioned for the removal of the CJ.
So if it so happens,
we know the members of the committee who are sitting for the removal of the CJ.
Who published that? How did we get to know?
Well, okay, so the name of the is Loretta Lamptey.
How did you asked the question? How we got to know about
the petitioners?
This
how did we get to know?
The petition got released to the public.
By who? Did that?
I don't know.
Aha.
I don't know.
When I say information will leak,
I'm just saying that the reason is simply because as we speak today. So, for example, there's a judge who is one of the petitioners who has petitioned against the current CJ.
Yes,
he was a circuit court judge, and somebody petitioned for his removal because he was involved in some relationship with somebody, another woman somewhere, and all that. And went through
what to do with his job.
Yes, but it was the ethics, and it affected the job that he was doing and all that. A committee was set up. The committee, we now know because of that petition. It was chaired by Justice Jamefe, who is now one of the nominees for the Supreme Court. It included the current acting judicial secretary. The current acting judicial secretary was part of that committee, and then others. And they adjudicated the process, investigated, and recommended the removal of this judge. And then he was subsequently removed by the CJ. The person is aggrieved, and he is petitioning the president against the current CJ for his removal.
What do you expect?
I mean, is it not bizarre?
What's bizarre about it? What are you telling me?
Oh, okay. Anyway,
it's a human institution. People's emotions, people's feelings will come in. It's not everybody who likes the CJ. There are some people who also like the CJ. But what we should always remember, as Oxford rightly said, it is the office. The president. What we should remember, it is his office, not the individual. How are we portraying the office? That's where the key is.
Mr. Janta, do you know the Chief Justice of the UK?
No.
You don't know the person's name?
No.
Do you know the Justice of the Supreme Court in the United Kingdom? Do you know any of them?
One or two of them.
Okay. Why do you think that the UK will protect their Chief Justice such that it's not the person is not this the person is not just available, everybody knows and all that? Why do you think the UK will do that? That put that kind of hardcore protection over their Supreme Court judges?
How many times do you hear a UK CJ speak in public? How many times? Rarely. What happens here in Ghana? The sacrosanctness of our CJ is exposed. Because sometimes you find the CJ everywhere and I'm generalizing, I'm not being specific, everywhere, talking when they don't have to talk, opening their mouth when they don't have to open their mouth. What does that do it? It makes them normal.
Incidentally, the Supreme Court, the Chief Justice of the UK is also a lady.
Yes.
Yes.
It's a lady. It's a lady. You hardly hear her speak or say anything. Everything could go through a certain process. And the judicial service, even the judicial service in the UK, sometimes you don't even hear them speak. It has to be something grave for them to come out. And normally, because it's a parliamentary system, you get some of these things being said in Parliament. The parliamentary
So the Lady Chief Justice of the UK is the Right Honourable the Baroness Carr of Walton on the Hill.
And she's in the, what do you call it, the upper house.
Yes, so she's the head of the judiciary
she's in the
of
upper
England
house.
and of Wales, and president of the courts of England and Wales.
Okra power.
Yes. So you hardly
hear.
but that for
But us, we've kind of, because we use politics for everything, we kind of don't see the sacrosanctness of the CJ. And sometimes they are to blame and we are to blame.
Okay, but Oxford, don't you think that the framers of the 1992 Constitution, from Article 1461 all the way to 11, felt that with regard to the Chief Justice office, before all of us as a country agree that we are elevating one person to go and sit in that high office, what it means is that we have gone through so much processing that by the time you get there, we have all agreed that your office is so sacrosanct that even if anything is said about you, we will make sure that because of the sacrosanct nature of your office, we are keeping everything away from the public, just because of the high nature of that office of Chief Justice, because you're occupying a space where it is so sensitive, we will not allow anybody to just infiltrate it. Don't you think that that is why the framers of the Constitution thought that with regards to the Chief Justice, let's make it so secret, let's make it so covered? I'm just thinking aloud.
It is.
Help me.
In fact, it is.
Supposed to be.
It's supposed to be.
Supposed to be.
You know,
That's
the
what it's
Chief Justice is supposed to be like the Pope. Supposed to be like the Pope. In fact, when I heard that, respectfully, the three justices of the Superior Court had met at a restaurant, you know what came to my mind? I started thinking that maybe every evening I have to go and sit there so that I can see them. Yes, because it's rare to hear that they are sitting somewhere and eating. Even we lawyers, before we were called to the bar, we were told that we can't even eat in public, not say in a restaurant. But there's some respect that you need to, you know, carry along the profession that you are practicing in. Do you understand? So the Constitution, I believe so. I believe, in fact, you couldn't even have heard about the petition. You know, maybe you get information that once upon a time the Chief Justice, even maybe after they had retired, then we will hear that, oh, even this Chief Justice was petitioning against removal, and they will talk a little bit about it. Don't now, because it's destroying everything.
Yeah.
Now, the argument we are making, we might end at a point that, oh, we have to, you know, make the whole process public, which will go against us the more.
And that is because right from the beginning, something that the framers of the Constitution thought that it should be so sacrosanct and secret
has been opened
has been
wide.
already opened up.
Yes.
So-
Yes.
so
And who
that-
created that?
That's actually
And who created that?
well, it is because of the politics.
Yes.
Of yes.
Yes. And the fact that it is up to a political body to nominate a Chief Justice, that should stop. Because if it was their own peers doing it, what you're describing would be solid. Solid. But you get the president to do that nomination. I think that thing is wrong. It is, and you see, we don't seem to be practicing strict separation of powers in this country. And because we don't practice strict separation of powers, sometimes it can be challenging to do that. The executive tend to override all the other two. Look at Parliament. President is supposed to take 70% of his cabinet, of his members from Parliament. What does that do, Parliament? It waters Parliament down. So if I am chosen to be Minister of Agriculture and I'm also in Parliament, and quite a sensitive matter comes up between the executive and Parliament, where do I stand? Especially remember, I'm a party member. Where do I stand? Maybe Parliament's case is good. Would I go for Parliament or will I go for the executive where I'm a member and I'm also a party member? It becomes challenging and it's not fair on that individual. It won't be fair on that individual. That's why the 1979 Constitution was good. If the president picks you from Parliament to be a minister, you resign your seat in the constituency. There's an election. New person comes up so that you can concentrate 100% on your executive role.
Okay, so I want us to just discuss this particular observation that was made by Justice Henrietta Mensah Bonsu in her dissenting opinion in Vincent Assefuah versus Attorney General, and it's on page 76 of the 81-page judgment. Wow. Now, the reason why I want us to look at the argument of page 76 is this. She says, and I'm quoting.
Have you read the entire thing?
I've read it, yes.
So send it to me.
I've read it. Okay, so I read it last night before I slept. But 76 says that, quote, she says, knowing the importance of the preservation of judicial independence in the court's ability to protect the citizens against powerful. Okay, so I think I didn't read it well. Okay, so knowing the importance of the preservation of judicial independence in the court's ability to protect the citizen against the powerful in the community, many are the provisions and safeguards provided under the Constitution. It is not for nothing that judges are required to take a judicial oath to administer justice without fear or favor, affection or ill will. How can the judiciary guarantee everyone's constitutional right to fair treatment if it cannot enjoy any such right when allegations of impropriety are made against the head of that institution itself? The people of Ghana will certainly be the poorer for having a judiciary that cannot protect them against the overweening power of the executive. Another class of citizens on whom there would be hardship is the class of persons who have made the decision to serve the country in the role of judges. Perhaps they may be forced to rethink their options and career choices if removing the head of the institution is not more difficult than removing a class prefect of a school from office. This is Justice Henrietta Mensah Bonsu. Very, very difficult comments, but I think worth taking note of.
Hit the nail on the head.
Your thoughts?
You see, I think she did well for the opinion that she wrote, and it was a bold decision, against all the majority concurrent by Justice Kolendi, and she wrote, and she made big point. If you look at the conclusion, she also mentioned that what you want to be done to you, or maybe maybe it's today is this person, it could be it's she was actually protecting the institution at this point in time.
Because you brought it up, let me read the conclusion. So the conclusion says that the golden rule of, quote, do unto others as you would have them do unto you is more is opposite. Yes. Then even in this situation, there are weighty issues to be addressed in this suit, and this cannot be done on the run. And while irreversible steps are being taken to prejudice the results of the constitutional challenge, therefore granting the injunction until a determination of all relevant considerations have been undertaken, would, to my mind, not only be dictated by caution and wisdom, but by the wider interest of the system at large.
Yes.
Unquote.
Yes. So as I was saying, she felt like there was a golden opportunity for the Supreme Court to delve into even the injunction application. You might say that, okay, when you get to the substantive case, but she felt that no, let's look at the points here and discuss them. For instance, we heard, or we know for a fact, that the only time we have even had any Chief Justice suspended was Kwame Nkrumah's time. So there are reasons for we having such a constitution to protect the institution, because it should be so difficult. Now, as we look at the process, it seems so seamlessly.
It says the removal like a class prefect.
You understand? Even this comedy show on TikTok, Cheddar the Bear Boy, it's difficult for you to remove them. How much more the Chief Justice, not even the Superior Court of Justice, just the Chief Justice. So she's right to say that it's coming from, she's actually explaining the law, but it's coming from a deep spirit. She feel like, no, please, let's look at all this point, because it's not about, forget about the person now, it's about everybody. As I'm saying, it's for the institution. We need to grow our constitution, and she actually made a point that, of course, it's a living organism. We need to grow with it. So probably some of the provisions as expressed here then could not make a lot of sense, but it's not making a sense now. As you mentioned that, okay, you got a petition, the next minute you were in public, and you gave the protection of the institution here. You gave the public opportunity to delve into the matter even before the CJ got the copy of the petition.
So that is captured in page 66 of the judgment.
Yes.
And in the page 66, she makes an argument about this whole media brouhaha.
Yes.
And so she says, for example, in the situation underlying the instant case, the media frenzy that accompanied the announcement from the president's spokesperson was to be seen and heard, to be believed. The public had not been informed of the content of the petition. Yet, with this little decorum or decency, the subject of the petition was tried in the media, and in a manner of speaking, ferociously thrown out of office by vociferous members of the public. The airwaves were thronged with legal and social pundits ranked on either sides to express opinions which the public lapped up with enthusiasm. The merits of opinions were weighed by those who believe they knew the content of the petition and cheered with approbation as people who had an axe to grind with the judiciary used the opportunity to mercilessly floor the entire judiciary. It was a sorry occasion for the judiciary. In such an atmosphere, what chance did the president have to consider the response provided objectively and to revise his opinion accordingly when performing the quasi-judicial function of determining whether a prima facie case had been made against the Chief Justice? The door to fair assessment of the response with an open mind was thus firmly closed when the furor engendered by the announcement, the furor engendered by the announcement released such vitriol towards the subject of the petition and all in the judiciary, that thereafter to not proceed with the processes when he received the response from the subject of the petitions, which he announced had already been activated, would have entailed loss of face and even loss of political capital.
So
very, very interesting.
Yeah,
very interesting arguments from Justice Mensah-Bonsu.
When you look at what Justice Mensah-Bonsu has said, isn't it ironic for the Chief Justice to want this thing to be heard in open camera?
Wouldn't it be wrong?
Isn't it ironic for the Chief Justice, based on what Justice Mensah is saying, isn't it ironic for the Chief Justice to want... Yes, exactly. Now, that she wants to hold this in open camera, because all the things she is saying there is protecting the judiciary.
The dignity
of the judiciary. And that is how it's supposed to be.
Yes, but what is also... The argument that I also see her making is that because you initiated the process and made it public, you have already sentenced the subject matter, which is the Chief Justice. The Court of Public Opinion has already sentenced her as guilty. So the Chief Justice is now saying that since the verdict there in the public opinion is against me, when I have not even been properly heard, then let's make all the world see when I am being heard.
No, shouldn't be so. Shouldn't be so. The sanctity of the judiciary is key. And for me, that is what the Chief Justice should have seen, irrespective of the fact that the public have said their own thing. But I asked the question, and nobody has been able to answer. Who exposed this particular issue? Who? Was it the President? Was it the Chief Justice? Was it the judiciary? This entire thing, who exposed it? The sanctity of the judiciary is key. And you know why it's key? It is the only place that gives resolve to the populace. The only place. If there is something that has been done against anybody, it is the judiciary they run to. It's the judiciary who can hear the case. It's the judiciary who can give a verdict on anybody who feels they've been disadvantaged. But unfortunately, the fourth realm of the state is such that it is politicized. So the fourth realm of the state, instead of doing their duty of even protecting information that comes to them, it is splattered everywhere. So you ask the question, was it a wrong thing for us to open up media in this country? Was it a wrong thing? Because the number of media stations in this country, when information gets into one media house, it's like the fall of a domino's brick. You know how domino's brick fall? When you line them up and you hit the first one, it falls all of them. So sometimes we should also question the media and how they handle sensitive matters. Would you say executive is sensitive? Would you say parliament is sensitive? Would you say the judiciary is sensitive? Out of the three, where do you find the most sensitivity? It's the judiciary. And especially in a high office of the CJ. It is something that we should start learning from and start putting things right. Because the same way we use politics for everything, it is seeping into the judiciary, and I don't think it is healthy.
Okay, so let me read these messages, and then we would go to the telephone line and speak to. We want to talk about the CD just before we end the show today. But if you have any other comment to make on the CJ, I'll come to that. But let me read these messages. Mrs. Jantwa, in-camera proceedings starts from day one, judging from the internal administrations, but yet confidential nature of these petitions. I think this is Nana Owusu's message. Okay, so the Supreme Court. The Supreme Court of Ghana has established that a prima facie determination under Article 146 cannot lawfully be made without first giving the accused judge a hearing. And if such a determination is made, response must be provided. Was this done? A defective determination can render subsequent proceedings void. And that is Abdul's message there. In Ghana, everyone moves the legal argument to suit their interest. Sometimes we need to put this legal stuff away and apply our common sense. This thing has to be on camera. What has NDC got to hide? And that is Christopher. Okay, so Christopher, thank you for your message on all other people. The other messages here, Mrs. Jantwa, who is Shining Star? The other two petitioners should have been resolved administratively at the Supreme Court or the legal council and not by the presidency. Wilberforce, I don't even know the names of the Supreme Court justices unless a case has been determined and the outcome published. Okay, that is Owusu's message. Since the inception of the new president to the Jubilee House, the ethos of the Jantuas change about the old president. There is a pepper. Somebody's just trying to attack you. I know. Okay, so in the UK, none of the political parties can promise their followers that they will remove the CJ when they are elected into office. Ghana, are we really a serious country? You get Nana Owusu's message. Nana Owusu's message saying that in the United Kingdom, the Conservatives and Labour can do everything, but when it comes to the Chief Justice office, you dare not. That's what he's trying to say. Samuel Yao Mensah says that it was Sami Gyamfi who leaked all the documents, including CJ's response and minutes from the Council of State. So yes, Samuel Yao says he has misinformation that it was Sami Gyamfi who leaked it. Okay. Maxwell Entry, Chief Justice, don't give up. Keep fighting until the end. And that is Maxwell's message to the Chief Justice. The Chief Justice is not fighting for survival, but is indirectly trying to prevent a mass coup d'etat of the bench. However, the potential beneficiaries seem to prefer to die by Article 146, also known as death by due process. So you get the message that Abdul is sending. He's saying that some people are trying to die by due process, and they should take note because they think that it is somebody else. You know, it's like I heard a pastor who lost his children the other day say that, you know, he has gone to several homes where people had lost their children, and he went there to console them. Say, oh, don't worry, it's okay, fine, everything will be fine. And then you preach all the word until his own children died. And then when his own children died and people started coming to his house, then he really got to understand that when you go to somebody's house and you are going there to go and sympathize properly. Yeah. Yes. Because it is only because it's not in your house. Yes. Okay, so
about you there?
Say yes, sir. No, I say so. Okay, so all right. So it was Sami Gyamfi who exposed it, and that's Maxwell Entry. Okay, I don't agree with Mr. Jantua. Your sister keeps moving from one TV station to the next, crucifying the CJ. Your sister can tell us who from the presidency did that. Okay, so that is...
Am I my sister? Well, why do they relate? My sister has her own mindset.
Yes, that's true. Kwabena Gyamfi has joined the conversation, and he says that my lay view is that once the process started with the public fanfare, we should grant the Chief Justice wish for the public hearing for the rest of the process. It's as simple as that, Mr. Gyamfi. All right, so Nana Owusu again is saying that, and today I'm doing the show with Abdul Basit Mahama and Nana Owusu. Nana Owusu is fast becoming second co-host. Wilberforce, we are being told that there are only 2 ex-lawyers on the Council of State. The president is a communications expert and making quasi-judicial decisions on this frivolous petition to the extent of establishing a so-called prima facie case against the CJ and his campaign promise to remove her makes it absolutely clear that this is a judicial coup d'etat. The judiciary must stand up and be counted. Okay. So last 2 messages, and then we'll go to the telephone line and speak to Dr. Domfe on the CD. I'll come to the studio and then we'll wrap up the conversation. Okay, so the other issues here. That is his sister. But how can you call somebody this kind of harsh words? So Mr. Jantua has a sister. Yes, Nanaya Jantua is Mr. Jantua's sister, but I will not read the words that you are using to describe her. Please, don't do that. Don't do that. And that is Maxwell Entry. Please don't do that. Please, I don't like that. Okay, so Kwabena Redu says that Why do you blame the media, Mr. Jantua, especially when you have a press statement acknowledging the receipt of petitions? Its members have discussed the details of the petition on the radio, and the president's spokesperson has also made a statement identifying the members of the committee that will investigate. So what is Mr. Jantua trying to say? So yes, that is Redu Atta making a comment about that, and I think initially I asked that same question here. In my opinion, the Chief Justice's request for the public telecast of her trial is to eradicate her publicly blackmailed. So let's read it better. In my opinion, the Chief Justice's request for the public telecasting of her trial is to eradicate her publicly blackmailed by the government's vilification. Okay, very good discussion as always, but sometimes it feels like giving up on Ghana. That is Eunice Champion. Eunice, please don't give up on Ghana yet. It's our Ghana. It's for all of us. We won't give up on it. Okay, truth be told, blatantly, it appears some persons don't mind going down with the ship as long as the captain dies too. The guts of the Chief Justice are hated with passion. They have got her the way they want. It is coded because I don't want to be picked up. That is Abdul Basit Mahaba. Last message. The Jantuas have similar minds when it comes to the defense of the NDC, even though they are different sets of people. So that is Baba Kamal. He says that you and your sister, you appear to be on the same path. You agree. You exchange your notes before you go on air.
I don't remember the last time
what you are going to talk about.
I haven't spoken to my sister in 2 weeks, so I don't understand what he's saying. Okay. But anyway, that's his opinion.
2 weeks is a very short time.
Yeah, that's his opinion.
Okay.
And when I speak to my sister, we don't talk politics. We talk family matters.
Talk family matters.
Yes.
Okay. All right. So, gentlemen, thank you for your messages. And let me check if Dr. Domfe is on the phone lines with that. Very good morning to you, Doc.
My brother.
Doc, thank you very much for joining us at the tail end of this show this morning. So the CD has been appreciating very fast. What is accounting for this appreciation of the CD?
Let me say very good morning once again to you and your listeners and the panelists, and also to the people out there, the very good Ghanaians, and let me assure them that they shouldn't lose hope. Things will one day get better. Yes, so CD is performing very well, and if you really want to look at why, there are so many answers that will come to why. First of all, let me start from where CD was. January 7th, when Nana Akufo-Addo was handed over power to manage the affairs of this country, $1 was going for 4 cedis 20 pesos. For 61 good months, CD was very stable. I'm talking about from January 2017 all the way to January 2022. 61 good months. We saw CD depreciating only about 54%. And if you look at the exchange rate data from 1957, there's no doubt about the fact that those 61 months, that is the first 61 months of Nana Akufo-Addo's 96 months, CD did very well. And so CD was already doing well. At that time, we didn't hear anybody speaking about dollar CD thing. We were already doing well. When all of a sudden, 2022, Russia entered Ukraine, and as soon as they did, a lot of things happened. One of it was the energy cost increases in energy prices. At that time, crude oil, a barrel was sold on the global market at $72. Immediately, Putin entered Ukraine, the price went up all the way to 121. And what does that mean? What that brought to Ghana and affected the city was that prior to prior to this event, one barrel, as I said earlier, was being sold for $72 and it went up to 121. That meant that those people who go out there to buy fuel to Ghana, I'm talking about the BDCs, instead of them using $250 million to import crude oil, they ended up spending $400 million. And that $400 million, they were taking it from Ghana. And so demand, the value of the cedi is demand and supply issues. Demand and supply issues. Now, anything that would take dollars away from the country will go against the value of the cedi. And anything that will bring dollars to this country also, in a way, helps cedi to stay strong. And so now, if you were originally using, I'm talking about the BDCs, $250 million monthly to export refined oil to Ghana, and suddenly you have to increase it to 400. It meant that there was 150 million additional pressure on the cedi. Now, as we speak, a barrel of crude had declined, I'm talking about the price, had declined to $61. And so at the moment, the BDCs, instead of the $400 million, they are now going to the global market with less than 200 million. It means less pressure on the cedi. So that's number one. Number two is the fact that today, as I speak with you, U.S. dollar itself is weakening because of our trade wars between U.S. and other countries. And so the dollar is no more attractive. And because of that, all international trading currencies have been appreciating against the dollar. And so it's natural that cedi also appreciate against dollar. But if you put it that way, you got it wrong, because apart from cedi appreciating against dollar, it is also performing very well against other international trading currencies. And one of the reasons beyond cedi performance against dollar is that the inflows of gold has also gone up. Last year, around this time, an ounce of gold was being sold at the global market at $2,300. Today, it has moved up to $3,300. About 33% increase. And so now, and again, the volume of gold exports has also gone up. That means more. We are now receiving more from gold, and once more dollars are coming, then obviously, cedi will become stronger. If you put this aside, one significant reason is also the fact that Ghana government has not been spending. Normally, government is supposed to be the biggest spender. They pay contractors, they pay statutory funds, and all that. And so when government spends so much, money in circulation, the velocity of money increases. When velocity of money increases, everybody goes to the market to demand. And so those who have gone abroad to bring goods, once people buy from them, they are going to change the dollars to go out there to bring more goods. But here is the case that now we don't have money in the system. People go to the market and nobody is coming to buy. If people don't buy, that one would have pushed you to the market to go and buy as individuals. So they will run out of stock to import has also slowed. And so that you could also attribute it to that one. Again, Ghana government has not been paying the energy and RPPs, the independent power producers. A few days ago, Car Power came out to say Ghana government was owing them $400 million. Ghana government is not paying. When government begins to pay all these things, definitely cedi will have a problem. Contractors, and we all know, the contractors, most of them are foreign owned. I'm talking about the companies that are that always win government contracts. Most of them are foreign owned, and the moment you pay them, what happens? They are going to take their monies away in foreign currencies. Today, Ghana government since the last 5 months, a penny has not been paid to these contractors, and so you can also understand why cedi is doing well. Another very important fact is that the money, the foreign currency that we use to service our debt and payment of amortization and all those things has also gone down drastically. We all remember at the end of 2021, Ghana was owing, our total debt stock increased to 50 billion. And Ken Ofori-Atta, the then finance minister, led the team to renegotiate or restructure our debt. Because of that singular initiative from Ken Oforiatta, our debt has now gone down to 44 billion. So about 16 billion total, $16 billion of our debt have been written off. Not only that, we have negotiated with the creditors. So what we should be paying at the end of every 3 months, now they have forgiven us, have given us that space, and so we are only paying about 25% of what we should pay. And this gives the government that room to rest. This also reduces the pressure on the dollar. And so that's another thing. But my brother, it's part of all what I have put together. The most important and the main reason why CD is performing so well in the last 3 weeks is because Bank of Ghana has pushed $490 million into the market. Bank of Ghana did this last month. I'm talking about April, And somebody will ask why that is helping the city to stay strong. Number one, Ghana, our exchange rate system is what we refer to as managed floating exchange rate. Ours is not completely floating. If it were completely floating, then demand and supply of dollar, then inflows and outflows of foreign currencies would always determine the value of the cedi. In our situation, it is managed. What managed means is that if the demand and supply does not help the cedi to stay afloat and cedi suffers any depreciation, then Bank of Ghana would periodically enter the market to supply. And so ours is managed. And we saw this last year when $1 went up all the way to almost 17 cedis around October, and Bank of Ghana entered the market to supply. So at the time Nana Akufo-Addo was hesitant, we were exchanging $1 for 14 cedis 53 pesos because Bank of Ghana have put so much there. And so the single reason, and that is the most important among all of them, a single most important reason why cedi is doing so well, especially against the dollar, is because Bank of Ghana last month alone pushed $490 million into the system. They did this when at the time Ghana government is not spending. They did this at the time Ghana government is not paying contractors. They did this at the time Ghana government is not paying independent power producers. And so you could see that the grounds are very fertile, and so the dollars that they supply, they are not in the system. People are not demanding because traders are complaining that the patronage to their goods has gone down drastically, and so people are not buying. And when that happens and you put so much into the system, definitely your city will become strong. Okay. And so, my brother, that is the key reason why city has stayed so strong for the last 3 weeks.
So Doc, because of time, let's add this question. Let's make it 2 in 1. Some have said that there is the concept of global lag, which is affecting this process, and then also whether or not what we are experiencing currently is sustainable beyond this month of May up to the end of the year and for the next 3 or so years of this government's administration. So talk about the effect of global lag on this development and whether or not it is sustainable going forward.
For the sustainability, for the current conditions that have brought what we are experiencing, if that is the only conditions to protect the city, then my brother, those who are saying it is sustainable, maybe they don't understand what is really happening to the Ghanaian economy. These factors are not sustainable because you don't control them. For example, Ghana government cannot say they will never pay the contractors. Definitely you will have to pay. Today, they are saying they are auditing the contracts. And so that is why maybe the contractors are not on them. In no time, they will run up and you can't say you will not pay them. IPPs, if you don't pay them, they may cut down power supply, and that is going to affect the economy. So for how long are you going to run away from paying some of these things? The statutory found that they are not paying, this is Assembly Common Fund and all that. For how long can you say, you're not going to pay all those things? The moment Ghana government begins to pay all those things, definitely the city would have a problem. But let me quickly also go to, one of the key reasons why we may see city staying strong for a number of months. Bank of Ghana today has about 9.4 billion, reserves. And this one, somebody will ask, what happened? Nana Akufo-Addo inherited $6.1 billion reserve with the Bank of Ghana, and that translated into 2.8 month import cover. Today, as I speak with you, we have over 4 month import cover. Nana Akufo-Addo, at the time he was exiting, had managed to accumulate total reserves of 8.98 billion US dollars, and that was 4 month import cover. And so, Bank of Ghana now has so much money. Somebody will say that you cannot give what you don't have. And so if it is managed floating, and Bank of Ghana's intermittent, periodic interventions into the market helps city to stay strong, they can only do that when, they have money. And today they have a lot. Why did they have a lot? One of the reasons why Bank of Ghana reserves have gone up so much is because of the IMF. The moment we went there, they promised to give us 3.6 billion US dollars. Sorry, that was 36 months, but 3 billion US dollars. That's what I should say. And now they've given us so much, and in no time, I think next month or so, they are still going to do out over 360 million. And so, I'm a Bank of Ghana, and because they are also here, they are helping us. One of the conditions for their program is that we should be able to maintain a higher reserves to protect the city. And so they are here as headmasters. They are here with their cane, making sure the Bank of Ghana maintains that reserves. But again, Ghana government introduced what they call BOG purchasing program, a gold purchasing program. Until we started this program, way back May 2023, the total gold reserves for Bank of Ghana was just 8.78 tons. Because they started buying gold at the end of 2024, our gold reserve had gone up to 30 tons. Today, Bank of Ghana is having 31 tons of gold, and that is part of the total reserves that we have. And so that bold initiative by the Nana Akufo-Addo government has really helped with the building of the reserves. And so Bank of Ghana now has so much. That's why they felt so good to intervene the market with a whopping 490 million US dollars. And so the bank has money now, but for how long? If we are not adding up so much, and they continue to intervene in the market to pay so much, yes, it will stay stronger. But as the Ghana government begins to pay contractors, as the US dollar picks up, that energy it used to have, and then contractors are paid, statutory funds are paid. When all these pressures begin to exert on the city, the Bank of Ghana, it doesn't matter the volume of reserves that they have today, cannot stop. They cannot stop it. So Doc, unfortunately, we've run out of time, and this conversation is going to continue on the morning show on Monday. And so I can assure you that we will get back to you so that you can educate us more on this. But there's a comment here that says that the cedi is a quick-tempered currency floating in a temperamental economy. Businesses must therefore prepare for its misbehavior without prior warning. Exporters are unhappy, but importers are excited for an improved cedi. Quick comment. 1 minute. Is the cedi quick-tempered? Okay, Doc cannot hear me. All right, so that's where we're going. I could hear you faintly. Okay, so we'll leave it there. Unfortunately, there's no time. So, Doc, thank you very much for speaking with us. We'll continue the discussion. Yes. Thank you. Okay, so that was Dr. George Domfe. He's a lecturer at the University of Ghana. So he's a development economist and lecturer at the University of Ghana. He joined us there. So that's how we are ending the show. Gentlemen, unfortunately, we've run out of time, but 30 seconds, cedi. Sorry with you, Osborne. Just 30 seconds, cedi. Oh, sorry, please. Yes.
So my point is that what we're looking for? I think for the appreciation of the cedi is good for everybody, but then we thinking about how we'll be able to sustain it. If we are not able to sustain it, it means that people need to buy a few things and it will shoot up, So we should appreciate the fact that we need more strategy and more intervention to make it sustainable.
Okay.
And again, this one is a Alberto board a chafrano, and yes, Sadan and Pafi. So it means that they are enjoying, of course, they are doing something, but we should also remember that the intervention made by the previous government also contributed to the city appreciation that we are seeing now.
Okay, Mr. Jantua, 30 seconds.
You know, the most important thing is to be able to find the strategies that would keep the city and even bring it down to single figures. And for me, one of the major things that we need to look at is our imports. That's where the demand of the city is heavily put in. The other bit is refined petroleum products. We should try as much as possible, because we spend a lot of money in bringing in refined petroleum products. We should look at how we can refine our own. We have oil, we have a refinery that is sitting idle. We need to be able to make sure that these two areas, the bit for imports are refined petroleum products, and those things where there's a huge demand for dollars, we should try as much as possible to make it in such a way that we keep this city where it is. Because I know a lot of people have sold a lot of their dollars because of the strength of the city. And I think it helps the country.
Okay, so from the report of Dr. Domfe, then, I can conclude that the economy of Ghana is sitting on a time bomb. The government must take a cogent decision in its escalation expenditure. Okay, so happy birthday to Barbara Sego of St. Peter's International School, Tadi. Happy birthday to you. And this is coming from Jimmy. Jimmy is wishing you, Barbara Sego, happy birthday. You are in Takrady in St. Peter's International School. And then happy birthday to Precious Kuduga. Yes, Precious Kuduga. And the message is, I thank God so much for addition. And you know what? Knowing you was never a mistake, because you have been so amazing and very, very supportive. I really appreciate and love you. And this is from Georgina Crunchy. Georgina Crunchy is wishing Precious Kuduga happy birthday. So that's how we are ending our show today. My guests who were on the show, Mr. Kwame Jantua. Mr. Kwame Jantua is a member of the CPP, and he is a lawyer in private practice. Now he's not practicing, he says. And then Oxford Osei Bonsu Esquire. Oxford is a lawyer, and he joins us with his beautiful daughters. Oxford, thank you very much for coming today. Earlier on, we had Nikwapo Samoa Ado, who had to leave us to go to another forum. Thank you, Nikwapo, for coming. Nana Eje Baffour-Awuah is a lawyer, member of parliament for Menchia South, and a member of the New Patriotic Party. He joined us first via telephone, and then you heard me speak there a short while ago to George Domfe, who is a development economist and lecturer, University of Ghana. For all of you who joined us via Facebook and sent us messages, I want to sincerely thank you for your messages. For those of you who joined us on ABC television, thank you for your participation. We hope to see you again next week. This show has been produced by Daniel Gidiglo together with Emmanuel Ohiming. My name is Wilberforce Asari. Thank you very much for the privilege of your company.
Thank you for watching. Like, comment, share, and subscribe.